Good morning, everyone. It being 9:01, we're going to go ahead and start the committee hearings for today. I would ask everyone to join me and Representative Marston in the saluting the flag, please. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. And I'm going to open the public hearing on HB 1246 FN.
Do we have somebody introducing the bill for Representative Gagne?
Well. Yeah, if you don't mind. Not even.
I have two. Both in support.
Thank you, Mr. Chairman and fine committee members. I am Representative John Burt. I represent Goffstown, Ware, and Deeren, and I am opening or introducing House Bill 1246. And if you could hold any questions for hopefully the prime sponsor or anybody else wants to testify. Thank you.
Thank you, Representative.
The committee calls Carl Huddleston, New Hampshire State Police.
Good morning, Mr. Chairman. Good morning, members of the committee. Thank you for hearing from me. I represent the New Hampshire State Police, and it was because of, usually when something comes before you for a change in law, it's because something happened, and that's correct. I happened to be working on the road one day with a couple other troopers, and we had a driver from Vermont driving a commercial motor vehicle who had a restriction on his license from the state of Vermont for an ignition interlock device. However, the commercial vehicle he was operating did not have one, and going through what the current law was, both state law and federal motor carrier regulation, the only thing that we could actually cite this guy for was for disobeying the terms of his license restrictions on another state, which obviously is an issue. So this will shore up the law so that it applies equally to everybody, and will give us another tool in our toolbox when it comes to commercial motor vehicle drivers that are required to have an interlock device.
Representative Testament.
Thank you. Thank you for taking this question. In a case like that, where you find somebody with a license that is noted to be interlock required, or however, do you then notify eventually through paperwork the state from which they came?
Yes, as a matter of fact, we did. We were able to get a hold of Vermont. Once the individual was convicted, that information went to Vermont. They did take further action against him on his license. But yes, we had a conversation roadside with one of the DMV directors over in Vermont trying to work through this problem. However, that was the only thing that we could do at the time. So this will help that along.
Representative Burt.
Thank you, Mr. Chairman, and thank you for your testimony. How many cases of this where somebody has a DWI in any state for a motor vehicle, but then their CDL, they're driving a CDL vehicle, how many cases where the person was under the influence driving a CDL?
That, I don't have the data on that, I'm sorry.
Thank you, Mr. Chairman. Because where I'm going with this is, you know, yes, his license was suspended for his vehicle, but this is a federal, you know, CDL is federal. So how can we, you know, make this law that's going, you know, to a federal license?
So, obviously, this will be a disqualifies the driver from operating. And there is both state and federal regulation, obviously, that prohibit somebody from driving while they're disqualified. So we would cite them under the state law. However, it also, at the same time, is federally noted, goes into the federal database, SIDLIS database, so that even if somebody from another state runs this particular individual's driving license, one, they can see the restriction on it, and two, as far as driving a commercial vehicle, if they have been stopped and inspected anytime prior within the last 10 years, we're able to get that information roadside as well, so we can see their whole history, whether it be state violation alone or federal violations. We have the access to that, so we would be able to better identify anybody that's driving in violation of this, or for any violation for that matter.
And one last follow-up, Mr. Chairman? Thank you. Well, I guess, you know, that answered it some, but, you know, I go back to that this is a federal license controlled by the feds. So why are we making laws in conjunction? You know, do we have the authority, I guess, is the real question.
Yes, we do. So, the feds, federal government, federal motor carrier, it's based on your home state's license. So, for example, the example I gave you, Vermont was the one that initiated the action against this driver for an ignition interlock because of a DWI conviction. That information is shared with the feds. They then put in their database that this guy is disqualified for these, whatever the reasons are. And there is a federal regulation violation for driving in violation of the restrictions that your home state put on your license, but the federal side of this will only take action once there's action taken by your license, home state, I guess is the best way to put it. Wherever you're licensed out of, that state needs to take the action against you before the federal side of this will kick in. So, state violation issued by the state, once a conviction is made, or once the person has been convicted of it, that goes into the federal database. That's when it becomes available to everybody. And at that point, if somebody was caught in violation like this particular driver was, there's a federal violation as well as a state violation. So this is the state violation here that we're talking about. Once that action has gone through the court hearing process, if they're convicted, it then hits the register on the federal side. Hope that answers your question.
Thank you.
Actually, I just have if you could clarify for the members, there's no federal DOT police out there that are doing it. It's up to the states. Could you explain that just a little bit so the members understand how that works?
So as far as the federal regulations go, there are a set of federal regulations for commercial vehicle operation. And there, as the chairman just said, there is no federal police, if you were, that go out and enforce this. There are members in every state and territory that have people that have been trained and certified to enforce these federal motor carrier regulations. So we're here in the state of New Hampshire, it's the New Hampshire State Police, Troop G to be exact, and there's 35 members that are trained and certified by the federal government to go out and conduct commercial motor vehicle enforcement. So no federal police, if you want to call it that. It's all up to the states and the territories to enforce it.
Thank you for that clarification. Representative True, please.
Thank you, Mr. Chair, and thanks for taking the question. If, I thought when you had a CDL, the state license was tied to the CDL. If you lose your state license, for whatever reason, you don't lose your CDL?
You do, and that's something that was cleared up a number of years ago. So, yes, your CDL is issued by your state, and if your home state takes action against you, it's directly, it's almost immediate, whatever the action is. If you get it, for example, if you get a ticket in California, eventually that information will make it back to New Hampshire. It will go on your driver's license. So yes, anything, any violation or any citation or any conviction eventually will show up on your license. However, if it's from an outside state, sometimes it does take longer for that to happen, if that makes sense to you.
Follow up.
Thank you, Mr. Chair, and thank you again. So in this case, when in Vermont, the operator is required to have interlock device, that doesn't carry over to your...
It does. The issue that came up was that we had no state law that allowed us to take an appropriate action against this individual. We had to cite them for disobeying the terms of their restrictions on the license, which is a $62 ticket here in New Hampshire. This would allow us to charge this individual with the actual violation of not having the interlock device installed on the vehicle he was driving, which is a far more serious offense, which carries a far more significant penalty.
So if I could clarify, a similar situation would be if I was driving, if I had a Vermont license that said corrective lenses, and I was driving in New Hampshire without my corrective lenses, you would be able to cite me for driving outside the restrictions of my license, but not, in this case, the more serious offense of not having the interlock.
That's correct. And we've had 2 instances that I know of in the last 3 years where we've stopped a commercial vehicle and an interlock device was required but was not installed. So it's not just one isolated incident. This is the one that drove us to be here today, but there have been other instances of this happening. And again, it's not a common occurrence. However, it is a significant offense. It's a serious offense, and we need the ability to cite the individual for the serious offense. And basically, we would be citing them, and they would be subject to the same penalties here in New Hampshire as if, in this instance, the gentleman from Vermont. So it's letting us enforce the same law the same way, I guess.
So in other words, you would be treating any out-of-state driver the same way you'd be treating a New Hampshire driver if they did not have their interlock device?
Correct, absolutely, yes.
Okay, thank you. Representative Newman.
What is the state police definition of a commercial vehicle? Because you see big vehicles that people rent that don't require a special license to drive them. I just wondering what you define as a commercial vehicle for the purposes of this law.
So for the purposes of this, it is the definition of commercial vehicle. It's a something used in commerce, obviously, that has a gross vehicle weight rating or a combination vehicle weight rating greater than 10,000 pounds. Doesn't necessarily require a CDL. That's greater than 26,000 pounds. But in this instance, we're looking at the broader definition, or the federal definition, I should say, of commercial motor vehicle was anything greater than 10,001 pounds used in the furtherance of a commercial enterprise.
Representative Muse. Oh, and hold on a second. Representative Newman, you had a follow-up?
So can a civilian driver that doesn't need a CDL rent a vehicle that fits that description, and would they then be subject to this law?
No. The big difference with any of these definitions is if they're used in the furtherance of a commercial enterprise. So technically, you could go rent a tractor trailer, an 18-wheeler, to move furniture from one side of the country to the other and drive it on an operator's license. It's the in-commerce that kicks all of the stuff in.
Thank you.
Representative Muse.
Thank you for taking my question. I am blessedly not too familiar with interlock devices, but it does strike me that a situation with a commercial driver might be one that their personal vehicle has an interlock device, and maybe their commercial vehicle does not. Are these devices portable? So if I'm required to have one, can I transfer them from vehicle to vehicle?
I am not aware if they. Somebody was going to answer that.
Yeah. Go ahead.
Thank you. I'll be more than
Senator
happy to answer that
Wallace.
question. As a former agent of the Commonwealth of Massachusetts court system for the purpose of calibrating, installing, and maintaining breathalyzer interlock devices, it is not portable and is not designed to be portable. It is permanently fixed into the motor vehicle and shall be inspected on a 30-day basis to make sure it hasn't been tampered with. And I do believe this is a cleanup bill because I assure you that all probationers, in other words, people that have these devices ordered by a court in their motor vehicle, are very much aware of what their requirements are to do that. They shall not operate any motor vehicle without the interlock device. They know this. They've signed off on it at least a half a dozen times through their agreements with the courts and the people and organizations that provide the equipment. So this bill, and correct me if I'm wrong, would simply provide us some recourse against individuals that may be employed as a commercial driver, and the rigs that they operate may not have this. They know that they have to have this equipment in whatever vehicle they're operating, even a motor vessel. So this just allows us to keep our roads safe for people that are being bad actors and trying to circumvent the system on a technicality. Would that be an accurate assessment?
Yes, it would. Thank you very much.
Thank you.
Representative Muse, follow-up.
Yeah, so essentially, one of the things that I'm also curious about is a situation. I guess how common it is for a commercial vehicle driver to actually have an employer who would install one of these things. So it seems like there would be a direct connection between a requirement to have a device like this in any vehicle you operate and your ability to work if that's what you do for a living.
Thank you for the question. And I was surprised, probably 6 or 8 months ago, I received a call in the office from a trucking company looking for the list of providers because they were hiring a CDL driver that required an interlock device. And I had a pretty candid conversation with the individual. To me, from a law enforcement perspective, employing a CDL driver that required an interlock device obviously means that that person has some significant history, bad driving history. And I think of the amount of insurance that's required on a commercial vehicle to begin with. And when you're employed by a commercial driver, as a commercial driver, all that information is relayed to your insurance company. And that's how they base some of their premiums, is based on type of vehicle, amount of miles driven, and the driving record of your employees. I can only imagine the added cost onto your insurance policy to try to employ somebody that's got at least one, if not two or more DWI convictions or another serious offense on their record. for whatever reason, this particular individual for this particular company was a valued employee and they were there to support him. I don't know that that would be the case for most. As you know, we're in a nationwide shortage for CDL drivers, and we still have a responsibility to make sure that the people that are driving these larger vehicles are responsible and obeying the law. And they do put them in commercial vehicles. We've seen them before. I think it's a huge expense on the company's part, but if they're willing to do it to support one of their employees, you know, we're there to make sure that they have the information available to them.
I think a lot of us have a question as to does this not disqualify you from a CDL license at the federal level? I mean, having an OUI, doesn't that automatically prohibit you from getting a CDL license?
Yes, there are a number of stipulations that go along with a conviction for DWI. For example, in New Hampshire, if you're driving your car, snowmobile, boat, motorcycle, and get convicted of DWI, first offense, the court will suspend your license for 60 days, depending, 180 days. If you do certain steps, you can get it back in 90 days. If you're a CDL holder, regardless as to what you were driving at the time, again, boat, car, snowmobile, motorcycle, whatever, your CDL's gone for a year. So that's automatic. That happens immediately. You can apply to get your regular operator's license back if you go through the steps, but you can't do that with your CDL. It's a minimum year. So there are a list of major infractions, if you will, in the federal regulations. You know, first offense DWI, it's a year. Second offense, it can be 3 to 5 years. Or even a second offense DWI can be a lifetime ban from obtaining a CDL. So there are significant penalties, even though you're not operating a commercial vehicle at the time that you committed the violation. However, just because you have the ability or you have a CDL, there is an enhanced penalty just because you hold that license.
So the person you're talking about, the Vermont person, he would have been after that 1 year automatic, and then he was able to do the CDL with the interlock device.
That's correct. Their law allows it as ours would too.
Representative Wallace.
Thank you, Mr. Chairman. And just for members know that people that have commercial driver's licenses actually have a lower threshold for being convicted of an OUI like us commercial pilots. I don't know exactly what it is, but I believe it's, what, 0.08 for a CDL?
So for a regular operator driving a non-commercial vehicle, it's 0.08. For somebody driving a commercial license that requires a CDL, it's 0.04. So it's half. That's only if you're driving something that requires a CDL license. Even though you have a CDL, again, if you got caught in your car, pickup truck, motorcycle, whatever, the limit would be 0.08. However, there is the enhanced penalty. Once you're convicted of it with any other type of vehicle, your CDL's gone for a year.
There be no further questions. We appreciate the education. Thank you, Staff Sergeant.
Thank you very much.
The committee now calls Brittany Shute from the DMV.
Good morning, members of the committee. My name is Brittany Shute, and I am the Bureau Administrator of Financial Responsibility. This legislation is at the request of the department, as Sergeant Huddleston has informed you. There are 3 pieces to this legislation, and I would like to speak to all of them further. Sergeant Huddleston's testimony here, but also to bring attention to Part 1 of the proposed language. What this allows is the Department of Safety to request a hearing on an individual, regardless of whether they're a commercial driver and operator who are convicted of a DWI out of state. So in the state of New Hampshire, if you are convicted of a DWI, you can be ordered to have an ignition interlock device, or you would go to a hearing with the Bureau of Hearings, who would determine whether you should be a program participant for an ignition interlock device. If you're a New Hampshire person and you violate out of state and you get convicted of a DWI, you are not subject to the ignition interlock program. through this legislation, we'll be able to bring these individuals in, determine the details of their conviction. Was it a first offense? Was it a subsequent? And should they be a program participant? Right now, we do not have that authority, so part one of this is applicable to both commercial and non-commercial drivers who receive a conviction for DWI out of state. Part two of this legislation, again, to further respond to your questions, this provides the authority for the Department of Safety Division of Motor Vehicles Director to disqualify a commercial driver who violates the ignition interlock program requirement. So if they are operating a commercial vehicle without an IID, the director does have authority to disqualify the driver. We must disqualify a driver on a state level before it goes to the federal level. So the home state, the state of record, is responsible for that disqualification. Part three of this further defines a serious traffic violation, which if a person is operating a vehicle, yes, without an IID, is circumvention. So with this, if a person was charged with this within a 2 to 3 year period, they would have a 60-day disqualification. It just further strengthens our ability, along with state police and the roadside troopers, to make sure that our roads are more safe with the commercial motor vehicle drivers out there. As Sergeant Huddleston stated, we have a shortage. It is anticipated that we get more drivers into these vehicles. They help get the country moving. They help get the deliveries out there. But while they're doing that, we want to make sure that should they have an instance where they do drink and drive, they do lose their license, they do get disqualified, and as part of rehabilitation, they are ordered as participation in the IID program. We want to make sure that they truly are doing everything that they should be doing and that we are all safe and that business is still moving. With that, I'll be happy to take any questions.
Representative Newman.
Thank you. And thank you for your testimony because it drew my attention back to Article 1. And so that is somebody who gets an offense wherever is then subject to going through a program that would determine whether they need an interlocked device or not. Is that a correct understanding of it?
Thank you for your question. What this legislation would do is to request a hearing of that person convicted of a DWI. They would go before the Bureau of Hearings to determine the facts and details, and if they are a person that should be subjected to an ignition interlock order.
Thank you.
Representative Burt.
Thank you, Mr. Chairman. This is kind of a two-part, as you explained part one, that we're going to enforce other states' laws here, you know, if they're DWI. Did the individual face more punishment back when he got back into Vermont? And then the part two is how many states do this, enforce other state laws?
Thank you for your question.
Yep.
In regards to the enforcement of state laws, New Hampshire is part of the driver licensing compact. So if you are convicted of a DWI in another jurisdiction, New Hampshire will treat it as if the conviction occurred in New Hampshire. So in regards to this Vermont driver, they depend, if he got a DWI within the state of Vermont and was subject to the ignition interlock program in Vermont, but was driving in New Hampshire, I really can't speak to that because I don't know if he was convicted in New Hampshire. In New Hampshire of a DWI conviction, we would apply applicable state laws, and then that home state, whether they choose to take reciprocal action under the driver licensing compact, would be up to their jurisdiction. I hope that answers your question.
A follow-up? Yeah, thank you. But so how many other states do what we're trying to do here? You know, so does Vermont enforce New Hampshire? Let's say the person gets arrested here in New Hampshire and he goes over in Vermont and drives. Does Vermont have this particular law to punish him?
I do not have that specific answer, but I will be more than happy to research that for you.
Thank you.
And I have a question, just so you could clarify it, please. This isn't necessarily proposing that we enforce other state laws. It's proposing that we recognize a conviction in another state and apply our own laws to it. Is that proper understanding?
Yes.
Okay, thank you. Representative Newman.
Thank you. This is just a follow-up to my previous question. So I'm not sure if you described this example, but it's someone from out of state who had a DWI in any jurisdiction and then gets stopped. would they then become, in New Hampshire, would they then become subject to a hearing in New Hampshire, or what, how would that work?
Are you talking about a New Hampshire driver?
It could be an out-of-state driver.
I think
I
only
think a
New-
New Hampshire driver, you would be subject to the laws and it would automatically happen. I'm just wondering how this law, the way it was written, would affect an out-of-state driver that had a DWI, and I don't know how they would know that. Maybe they'd do it when they run the license.
Thank you for your question.
What would happen? So,
I will attempt to answer that. So in the state of New Hampshire, if you're an out-of-state driver and you are convicted of DWI, statutorily for the ignition interlock program, it has to be a subsequent. So in that case, if you're statutorily required for the DWI conviction as, say, a Massachusetts driver in New Hampshire, we can order ignition interlocks for people that reside in another jurisdiction who are convicted of DWI in New Hampshire.
Representative True.
Thank you, Mr. Chair, and thank you for taking my question, ma'am. If this had happened, what this bill is addressing had happened in New Hampshire, and the person lost their license, their CDL license for at least a year, as we heard on testimony, it would be the state of New Hampshire that would tell this person after a year, you can now activate your CDL?
Thank you for your question. The home state is the only state that can disqualify a commercial driver. So a Vermont driver that comes to New Hampshire, as Sergeant Huddleston was stating, we can cite them for operating outside of the ignition interlock. What we can't do is we cannot disqualify the Vermont driver. What we can do is report that information back to the home jurisdiction, who would then take action in accordance with their laws. What this does here is this provides the authority for the New Hampshire Division of Motor Vehicles to disqualify a New Hampshire commercial driver for operating a commercial motor vehicle without an ignition interlock when subject to an ignition interlock.
Thank you, Mr. Chair, and thank you, ma'am. Let's say this happened to me in New Hampshire. I have a CDL, I'm supposed to have an interlock device, and I'm driving a CDL vehicle without the interlock. And I'm found guilty of that. Would I lose my CDL license in New Hampshire?
Yes, this provides me the authority to disqualify you as a driver for not complying with the ignition interlock requirement.
This bill does.
Yes, it provides me the authority to do that.
Thank you.
Thank you.
There being no, Representative Harriet Gathright.
So thank you for your question. If a person is operating a commercial motor vehicle, as Sergeant Huddleston indicated, we would only be able to cite them for the $62 violation of not obeying the restrictions on their license.
There being no further questions, thank you for your testimony. Is anyone else here who wishes to speak on this bill who was not signed up? There being none, I'm going to close the public hearing on HB 1246. Can you pass these out? I'm going to go ahead and try and exec maybe one bill. Pass these out. I've got an amendment I'm going to pass around. Yeah, it's the notorious purple paint bill, 1108.
going to open up the executive session on House Bill 1108, and the committee recognizes Representative.
And I broke the whole thing.
There.
How about now? We good?
Yep, we've rebooted.
All right, my bill will be in the mail. I am introducing an amendment to Representative Reed's bill, HB 1108, the purple paint bill. So we heard testimony about it. We heard from the environmental police. We heard from some landowners. I think all of us have seen some emails on this. I think that there was some good in this bill. In my opinion, for an elderly person or someone who can't get around good, to have to go out and put these signs up every 100 yards and maintain them is very difficult and expensive. Also, at the same time, allowing people to just run around putting purple paint leads to other issues that could hurt hunters and people just wanting to enjoy the outdoors. So I felt like a compromise was in order. So this is what we came up with. Right now, currently, you have to have a sign every 100 yards in the woods with your name, address, and information on it. This amendment would make it so that you had to have a sign every 250 yards, so I've more than doubled it. But in between that, you can put purple paint on the trees. So if you're in the woods, you're a hunter, you're just an outdoor enthusiast, if you see purple paint, you know that you don't have to walk more than 100 yards in either direction, and you'll know who owns the land and if it's properly posted or not. So I think that's a compromise for landowners, outdoorsmen, hunters, everybody, that will make it easier on property owners in New Hampshire to be able to mark their property if they so choose. Also, there was concerns about people just running around willy-nilly spray painting purple paint everywhere. I've added a punishment if they do that. If you're caught spray painting property that's not yours and you don't have written landowner permission, first offense would be a misdemeanor. Second would be a Class B felony. And you'd be responsible for going and fixing all the trees you damaged. And if that means you got to walk around and spray paint them brown again, it's up to the court to decide. But so I've given it some teeth, and I've made a compromise. I hope that you'll all think about it. And I'll take any questions.
Representative Rhodes?
Thank you, Mr. Chairman. Thank you, Representative. Just a quick question. The signs that are up now, refresh my memory, are they yet, like the posted signs, are they yellow? Or what color are they?
I think, I'm not sure, someone can correct me if I think they just have to be white. I'm not sure if they have to be yellow. They just have to be a certain size. There's a certain measurement and certain information that has to be on them.
Okay.
Does anyone know if it's going to be yellow?
Follow up?
So would it, I'm just thinking, when I was here, when we were listening to this bill, and there was a lot of confusion over the different colors, and people don't know what purple was, and I remember the people from like the forest industry were here speaking about that. Would it be, I guess I'm thinking, would it be, if they're going to use spray paint instead of making like elderly, like you're saying, because I see that point, would it be better to just have it all be the same color instead of changing it to the color purple?
I think the purple thing is because there are numerous states that have adopted it, so it's starting to pick up and starting to gain knowledge, I think, is where the purple came from.
Representative Testerman?
I don't know how to put this.
Be gentle.
I'm going to oppose this. I think this is a ludicrous bill. So the question really is, why are we wasting time on this?
I guess I would ask the chair why you're letting him talk to me that way, but I'm going to go ahead and I'm going to pass on that. I'll tell you this. We should, as a committee, we could have dealt with this a week ago, and in the meantime, it's generated a lot of public interest. I myself have received hundreds of emails and at least 70 from my own constituents. that liked the idea. So I'm here to do my constituents bidding, and they wanted it, so they got it.
Representative Welch.
Yes, I'm going to support this, not because I'm really enthusiastic about it, but if we amend the bill, this will be the bill that we'll hear in a session, and that'll be far better than the original.
Thank you.
Representative Muse.
Thank you for taking my question. Taking a look at our criminal mischief law, we have a maximum. It looks like what you may have tried to do is to try to mirror the marry the penalties for violation of this particular law. So, spray painting purple paint without permission. Were you trying to mirror the criminal mischief law?
To some extent, but this is its own offense with different ramifications than a criminal mischief law. The ramifications for this could be if you were to do it without permission. If you walked around and spray painted a couple hundred acres of trees and you didn't have permission to do it, the ramifications are far more than just criminal mischief. That's a lot of work and expense to fix that. So I felt like a second offense, after you've been properly warned, don't spray paint people's property without permission, and the cost of doing it, I felt justified a little bit stiffer of a penalty for a second offense.
Follow up, Representative Muse.
It's one of the things that does concern me is if you look at the criminal mischief statute, which is 634:2, it is a lot more specific about how the misdemeanor penalty would be applied versus the Class B felony penalty. And I guess is your feeling that we might need more of that type of detail in this amendment before we act on it?
I think that it applies equally to both the first and second offense. I don't see where the specification or the specificity drops off. It just says that the second offense will be a felony versus a misdemeanor. If you're asking me about the specificity as far as paying for or fixing the damage done, but let's.
I raise it just simply because it looks like what you're trying to do is to turn illegally spraying paint into really a form of criminal mischief, and I was just wondering if it would make more sense just to reference the existing statute than to put potentially conflicting language into the statute.
I don't know. We could discuss that. Let me go back to the chair unless you have another question about it.
Representative Bourdonnais. Waiver.
Maybe it'd be more appropriate if we just open it up to executive discussion for the session.
Yeah. Representative Burt.
Thank you, Mr. Chairman, and thank you for taking my question. Have you ran this by, and do you have support of Forest and Lands, New Hampshire Forest and Lands, Jason Stock, New Hampshire Timber Association, Land Association, and Fish and Game that oppose this because they tried it in Maine and they're the laughing stock?
I have the support from the Fish and Game, said they supported the compromise. I did not discuss it with the timber people. I have the support of my constituents, I know that. So whether the timber folks like it or not, I know that it's being done across the country in many states. How Maine handled it, I don't know.
And one follow-up.
Follow up.
Thank you, Mr. Chairman. And I am looking at the penalty phase,
Yes.
which, I support people should be punished if they harm other people's property. The first time is a Class A misdemeanor. I believe that's a year in jail, could be.
Maximum.
Yeah, max, yeah, and I think up to a $1,000 fine. But then the next fine is removal of your guns if you're convicted of a felon. So that concerns me because I'm thinking, you know, the graffiti on the billboards that we see everywhere and on buildings, I don't think it's even a felon there. So I want to check that out before, you know, hopefully I can check that out before we go to a vote. But where is the fiscal note on this? Because there is a huge fiscal note now that should be applied to this so we can pass this amendment.
Why, with regard to the incarceration possibilities?
Correct.
Yeah, they didn't give me one, so we can send it back and ask for one. It would probably go to finance, I guess, anyway. With regard to your question about the different punishment versus, you know, losing guns and stuff, frankly, I gotta be honest, if you're convicted once of spray painting somebody else's property so that people can't go on it, and then you do it again intentionally, the consequences are well known to you, and you reap what you sow.
We're going
Yeah,
to
I'd like
move
to-
to executive session
Yeah.
pretty quick. Representative Bolden, one question.
I don't have a question. I mean, I don't have a question. I just have commentary. This is an executive session, right? So
Yeah,
I
it's
don't
co-
think that the format of having a person
Yeah,
like
that's
giving
all I'm-
testimony is correct. I think, just some feedback. I think that we're free to all just discuss the bill however we'd like, and we don't need to treat Representative Roy like a witness, as the chairman, as the Daryl would normally say. And so in that vein, since it's just exec session and we just talk about what we think of the bill, because if it was a public hearing, it would need to be properly noticed,
Correct.
which it has been. But in that vein, I just wanted to mention that it makes sense to just nix section 3, if that's not too bad. And I would recommend just pausing and getting something new from OLS. It seems like it's pretty straightforward based on what I'm hearing.
Point well taken. The process was to have Representative Roy introduce the bill and have a work session, which is what we're doing. It's a bit ad hoc, but
Yeah.
we're getting the work done, so.
Yeah,
That's been a
I'd
lot
like to
of
go
fun.
back to my seat, though, because I'm feeling very uncomfortable and attacked up here.
I'm sorry, I believe work sessions also need to be noticed in the calendar. Is that, if
Well-
this is a work session, it needs to be noticed. But
And
if
it
it's an
is.
exec session,
On the bottom
then
of
we're
this,
all
executive
set.
session on pending legislation may be held throughout the day. time
believe we
permitting.
can have
So
discussion.
it's
Just
properly
want to
noticed.
clarify that it can't
It's-
be a work
It's
session.
on today's notice.
Thanks.
Okay, back in this. Yeah. What we're going to do is we're going to go ahead. I think. Yeah, I'm going to recess the executive session. It sounds like there's some support, some not, and I will. I'll work on that, and we'll come back with it after. So I'm going to recess the executive session, and now we will stand in recess until 10 o'clock.
start with the, Good morning. At this time, we'll now open the public hearing on House Bill 1085 relative to ignition lock requirements.
First signed up to speak, Representative Laura Telereski.
Good morning. Thank you, Mr. Chairman, and thank you, colleagues. For the record, I'm Laura Tulersky, and I represent Hillsborough 35, which is Nashua Ward 8. Today, I present for your consideration House Bill 1085, relative to ignition lock requirements. The issue this bill addresses first came to my attention back in 2020 in the form of HB 1465, when Representative Sykes submitted the bill at the request of the DMV. It came out of House Transportation with an ought-to-pass motion and passed the full House on the consent calendar on that now infamous House session on March 11th and 12th, 2020. From there, it was lost to COVID in the Senate, where it died on the table. Several months ago, I had a conversation with Director Bilecki about DMV bills that had been lost to COVID, and she asked if this bill could be filed again. I won't go into too much detail on the Interlocked Devices, since the previous bill also addressed what they actually are. But briefly, an ignition interlock device is a small handheld breathalyzer for car ignitions that is installed to prevent users from starting their vehicle after drinking alcohol. What this bill does is clarify the language on which vehicle needs one of these devices. If I can direct your attention to the bill on line 5, it reads that a device should be installed, quote, in any vehicle registered to that person or used by that person, quote, on a regular basis. It's that phrase, on a regular basis, that is the problem. I think we can all agree that if you own a car and it's the primary car you use to drive to and from work, that car is used on a regular basis. Therefore, that vehicle will need an interlock device. But what about the car that is registered to your spouse that you only drive on weekends? Technically, is that on a regular basis? Would you need an interlock device on that car? Then perhaps you borrow your friend's car to run an errand, or maybe use your neighbor's pickup on the weekend to make a run to the dump. Again, both of those scenarios, would your vehicle need an interlock device? Because are you using it on a regular basis? This bill simply strikes out that problematic phrase, clearly changing the statute to reflect that an interlock device must be installed on any car used by a person who has been convicted of a DWI offense when in the process of reinstatement of their license if ordered by the court. In layman's terms, this clarifies the intent and closes an unintended loophole that currently exists. It's my hope that this committee will see HB 1085 as a simple language cleanup and find this bill ought to pass. Thank you.
Representative Newman.
Thank you. Could you just clarify if this bill, as we see it here and where the language is stricken, was that language stricken in the previous bill and this is just a cleanup of the previous bill as it was, or is this in addition to what may have been on the bill that was left on the table?
Thank you for the question, Representative Newman. This is the exact bill that died on the table in the Senate. It just was never able to be brought up and presented to the Senate.
Thank you.
Representative
Thank you, Chair. Thank you for taking my question.
So this bill now requires that if am required to use an Interlock device on my vehicle, and I have 3 vehicles, only one of which I drive, all 3 vehicles have to have Interlock devices.
That's what the intent of this bill would be, that if you potentially have 3 vehicles in your possession, this would mean that every vehicle you could potentially drive would need to have an interlock, or any vehicle you ever sit behind the wheel and turn the ignition.
Follow?
Representative Bournet, recognized for follow-up.
Thank you, Chair. Thank you for taking my question. Wouldn't it be easier and better to require that anybody that is required to have an interlock device while they're driving to have an interlock on device that they're driving versus having all their vehicles have interlock devices?
Thank you. I think I'm maybe answered your previous question then. This bill, is the way I understand it, and I'm sure that there might be someone who would testify after me, cleans it up to say that any vehicle a person drives would need an interlock device if they have been so ordered by the court. Whereas the existing statute has that loophole where it says, in any vehicle you drive on a regular basis.
Thank you.
Representative Testerman.
Thank you, Mr. Chairman. Thank you for taking my question. Isn't the reason for this bill, or for a bill like this, is to make sure that people have an interlock device if they're driving a vehicle? I think I tend to agree with Representative Bournet that that's the issue. It's covering all the cars. If he doesn't drive them, or if he only has one that has interlock, that's the one he ought to drive. And if he gets stopped, he's got a penalty. But I can't see, and do you think that we ought to require everything that he has a potential of getting in because it happens to be owned by him or a friend is a logical way to do it?
Thank you for the question. This bill does not mean someone who is subject to an interlock needs to install an interlock device on every vehicle registered to him. It simply says that any vehicle he drives must have an interlock device.
Representative Harry Gathright.
Sorry. Thank you, Mr. Chair, and thank you for taking my question. If you look at line 23, it absolutely says, in any vehicle register to the person. And I think that's what they're referring to, because it does say that, or used by that person. So it does state, for me, I have 3 cars. So I would have to have an interlock on all 3, whether I'm driving it or not. That's what this bill says.
Thank you. And I agree with you, that is what it says, and that is what the statute states now. The only change that this bill is going to make is to clarify that any vehicle that someone's subjective to this interlock device order, any vehicle they drive would need an interlock device.
Representative Bournet.
I think we need to fix it.
Thank you. Thank you for taking my question. Does vehicle in this case only mean automobile? Does it include snowmobile or boats?
Thank you for the question. I may have to defer to someone in the DMV on that question.
Representative Green.
Thank you for taking my question. What about motorcycles?
I again would defer, but I would assume that a motorcycle would fall under the regular motor vehicle statutes.
Representative Sue Newman.
Yes, thank you. Excuse me. Thank you for taking the question. I just glanced very quickly at what costs for interlock devices are, installation, servicing, or whatever, installing, servicing, and then removing it, it can get very expensive. I would think, I'm not opposed to this, I'm just thinking, there's a question here. Oh, I'm struggling with it. There is a question. A question would be, as a public service with people being against DWI, exposing the cost of all of this might be could be a deterrent. That's not a very good question, but I'm done. Thank you.
I'm not sure that there was a question there. I was still waiting for it.
Thank you, Representative Newman.
If I may, if the chair may inquire with the question, and so if I was convicted, hypothetically, of an aggravated DWI offense, so I would have to put an interlock device into my own vehicle. If you were gracious enough to let me borrow your vehicle, what would happen in that scenario?
Under today's statute, my interpretation would be that you would be able to drive my car because you don't drive my car on a regular basis. This bill, what I understand, would close that loophole, and it said that you would need to use it by that person, period.
Thank you. Representative Conley.
Thank you, Mr. Chairman. Thank you, Representative. Is the intent of this bill solely that somebody who is required to be operating with an interlock device uses an interlock device when they operate a motor vehicle?
Yes, thank you for the question. The point of this is to make sure that anyone who is subjective to the order of using an interlock device must use an interlock device on any vehicle that they get behind the wheel and turn the ignition on and start driving.
Representative Roy.
Thank you. And just to follow up on Representative Conley, this bill does not mandate installation of extra interlock devices in vehicles. It just mandates that the driver only use one that has an interlock device. Is that correct?
Thank you for the question. In the previous bill, someone stated that if someone's subjected to this order, they understand what it means and they learn all the rules. And I believe that this bill simply codifies one of those rules, which is you need to use an interlock device if you're driving. That's what this bill does. It makes sure that someone who should not be driving with anything other than an interlock device cannot. It does not mean that they need to go install one on their mother-in-law's vehicle or their neighbor's vehicle.
Thank you for your testimony.
Thank you very much.
Good morning, Mr. Chairman. Good morning, members. Thank you. Just briefly, we, with the Department of Safety, State Police, support this. The testimony we've just heard covers basically everything I was going to say, other than this is to make sure that any vehicle that a person subject to this regulation operates a vehicle that has an interlock device in it. Basically, we're just trying to make sure that they're complying with what the court has mandated.
Representative Welch.
Thank you, Mr. Chairman. Do you think that it would be worthwhile if somebody's convicted and is subject to having an interlock device, that if there's 4 cars registered in that family, that all the license plates should be marked?
That's a unique question. I don't know that. I think somebody from the Civil Liberties Union would probably have a problem with that. Marking somebody that way, I don't know that we would support that.
Further question?
Representative Welch, recognized for a follow-up.
Back along, several years back, we had a judge come up here from Ohio. And in Ohio, they had a deal where everybody in that household got a yellow license plate, which meant that anytime they saw that car with a yellow license plate, they could stop it to check to make sure that it wasn't the convicted driver driving it. And that, in some families, you have an enabler who allows, let's say the husband is a drunk, and the wife puts up with it, and the wife has to go grocery shopping, and there's a shame attached to that. I think they have elected judges in Ohio, and I don't know how that judge survived, but that was the scenario. It was to make try to convince the guy who was drinking all the time to not drink.
That's certainly a novel approach.
But seeing that there was not a question, I'll leave it to the witness to. And we'll just cover this now. Members are recognized to ask questions of the witness to obtain information, either about the testimony or about the bill. We are not permitted to debate the witness and would not make generalized statements. Even if I agree with the statement you're making, it's not in order for that to happen. So I would just ask that we make it through the day without having to bring this up again. Representative Bourdonnais.
So, can you define vehicle? Does it apply to snowmobiles and boats and motorcycles?
In this instance, yes, the term vehicle is any motorized mode of transportation. Wouldn't be a bicycle, but snowmobile, motorcycle, boat, ATV, UTV, anything that's motorized.
Representative Bourdonnais.
Thank you, Chair. Thank you for taking my question. Are interlock devices available for all these types of vehicles?
I believe they are. Obviously, they're not as common as one for a regular passenger vehicle, but yes, my understanding is that they can be installed on anything.
Thank you very much.
Thank you for your testimony. Oh, Representative Harry Cathright has a question for the witness, if you don't mind.
I realize that the information that I asked about on line 23, and I thank Representative Tulerski for helping me to remember that this is already in the bill, but would you have a problem in taking that piece out, what that refers to, line 23, where it refers to all cars owned by the person?
So what you're asking is that would we oppose the language that said any vehicle registered to that person, striking that and just have it to be, say, any vehicle used by the person?
Used by the person, exactly.
I don't know that we would oppose that. Because, yeah, there are people that use vehicles that aren't registered to them on a daily basis as well. So I don't know that we would oppose that. That's the first I've heard of that, though.
Thank you.
Thank you.
Representative.
Thank you, Mr. Chairman. Would you agree with me that that language also appears in line 5 and would need to be amended there?
Yes. No. Somebody else will speak to that in a minute.
Thank you for your testimony. This is just my interpretation of the difference between line 5 and lines 23. Lines 23 applies to someone who's under the age of 21, where lines 5 would apply to, I presumably, someone over the age of 21. That's just how I read it.
Or both. Sorry.
Well, when there's a subsection that's different that specifically addresses the age 21 and under, I would interpret that if the prior section would not apply.
Okay.
And it only applies to aggravated, this is involving an individual that has an aggravated DWI offense or has had a subsequent offense conviction. And anyone may correct me if I read that wrong. Clerk may call the next witness.
On House Bill 1085, we next call Brittany Shute, DMV.
Good morning, members of the committee. A lot of great conversation going on here, and I'm hoping that I can provide some clarification to your questions to the best of my ability. And if I cannot, I will be certainly happy to mark those questions and get back to you. This bill is at the request of the department, and yes, removing on a regular basis does help clarify to people subjected to the program that they can only drive a vehicle equipped with an IID. There are instances, again, where this is my wife's car, I'm running to the store. What it does is it makes it consistent with the subsequent chapter 26337, which is circumvention, and that states any vehicle. Technically, a person who's operating a vehicle without an IID, that's circumvention. So what we want to do is strengthen this program and make sure that it's clear to those program participants what their expectations are and that there's no ambiguity in the law to prosecutors and the program participants, law enforcement. It really brings the program all together to make sure everyone understands their responsibilities, because as mentioned, these ignition interlock devices can be costly to a person. And what this is saying is that if a vehicle is registered to a person, they have to have an IID. If this person is using the vehicle on a regular basis, or actually removing that, if they're using a vehicle. So in a household with a husband and wife situation, let's just say vehicle is registered to the husband and another vehicle registered to the wife. If that vehicle is registered to the wife and the husband is not using that vehicle, does not touch it, does not think about it, doesn't even think about thinking about it, they do not need to install a device. What the person's responsibility is to drive a vehicle that is equipped with an ignition interlock device. It's really important that they are complying with their restriction. So to answer some questions here, in regards to marking a person's plate, it is technically already in statute that the department can mark a person's plate. Do we practice that? No. In regards to line 23, yes, it's pursuant to people who are under the age of 21. If a person is under the age of 21 and has multiple vehicles registered to them and they're drinking and driving, we really need to make sure that we are focusing on that person to make sure that they're complying with the program and that they're rehabilitating in a proper way. While yes, it can be monetarily expensive to that person, if they are only driving one vehicle and they only have one vehicle registered to them, they are at the same as any other person who is subject to an ignition interlock device. With that, I'll be happy to take any questions.
Representative Green.
Thank you, Mr. Chair. Thank you for taking my question. Could you give us a figure what it would cost a person in 1 year to have that device put on their vehicle?
Great question.
So you looked it up, right? No, what did you find? Like $1,000 or?
I'm actually going to have this gentleman here come up and answer that question specifically, so that way you have better information, if you don't mind. Since you're here.
But there's 2 seats there for a reason. Thank you.
For the record, my name is Robert Blaisdell, and I represent Consumer Safety Technology in Tuxalock. We're out of Des Moines, Iowa. And I've been involved with this program ever since the early 2000s, all the way back to the RFP process. To answer your question, Representative, my understanding is it's for the installation, it's roughly about $150. For the daily cost, it can depend, it's anywhere between $2.50 to $3 a day. What we're finding, though, is that some of these costs are rising to like cars such as like Teslas, for example, where it's a little bit more complicated. But that's roughly what I'm aware of. It's $150 to put it on, $150 to take it off, and then roughly $2.50, $3 a day.
Representative Pratt?
If you didn't have this ID system in place, the appropriate thing would be to take the person's license for a long period of time, correct? 'Cause this is a multiple offense.
Thank you for your question. In the scenario when a person is subject to an ignition interlock order, they do not have the ability to wait it out. They must comply with the compliance requirement, which is the installation, if they are so ordered by the Department of Safety or the New Hampshire court system.
What I meant to say was, another quick follow-up.
Recognized for a follow-up.
Thank you. What I meant to say is, if we didn't have this whole program in place, the IID, the appropriate thing to do for somebody who's been convicted for drinking after revocation or not having a license would be to say they couldn't drive, period, for a period of years or whatever.
Thank you for your question. A person who's convicted of DWI would serve out their suspension period. If they are then caught operating after suspension or revocation, yes, there's additional sanctions. And if a person chooses not to install an ignition interlock device as a condition of restoration, then they will indefinitely remain suspended until they comply.
Good. Thank you.
Representative Roy?
Thank you, Mr. Chairman. Thank you for taking my question. Pardon my voice. I think there's just a little confusion, and I want to clear it up. Why are we getting involved in, which vehicle or this vehicle versus just focusing on the operator and saying you cannot drive a vehicle, I don't care what it is, without an interlock device, and then putting the penalty on the driver? Why are we starting to get into which vehicle has what and installation and all this stuff? If the driver's only able to drive with an interlock device, bottom line, why even get into the vehicles?
I think that is a great question. Thank you. The focus is on the operator of the vehicle and making sure that they understand their expectations, that they cannot operate a vehicle without an ignition interlock device.
Follow up.
Representative Roy, recognized for a follow-up.
So the bill needn't only say an operator subject to an interlock device may not operate any vehicle that does not have an interlock device. Is that not simple enough, just like that?
Thank you for your follow-up. I think that is fair language, and we are certainly open to addressing the ways that we can ensure that people are only operating a vehicle when they have an IID order, and taking the ambiguity out of the law and making sure that there isn't that space for them to say, well, I don't operate this vehicle on a regular basis.
Okay. Thank you.
Representative True?
Thank you, Mr. Chair, and thank you for taking my question. I know it's in the RSA now. However, in 3 places in the bill, it's mentioned that, and any vehicle registered to the person. What would be your department's position on removing the wording and that you'd have to put this in any vehicle registered? Do you see that as a problem?
Thank you for your question. Are you asking if we put any vehicle registered to them?
No, if we strike that, if that were in an amendment, if that were removed, the wording that they had to put this device in any vehicle registered to them. I'm asking because, as you said, the purpose is to make sure the person under this court order follows that he doesn't drive any vehicle without a device installed in the vehicle.
I think that is a great question, and I think I would need to further assess that to give a better answer. Because again, we have to understand in totality how that impacts the driver and their vehicles and what they're doing on the roadways.
Thank you. Thank you.
Representative Conley?
Thank you. And not to belabor this, but the representative who just asked a question, or maybe it was just before, said if we clarify the law to say that somebody's subject to these requirements uses this device when they drive, does that not meet the criteria and the goal of this bill? Rather than getting into however many vehicles they own and so forth, is that clarity something that we can go for?
Yes, absolutely, and I apologize. I see how the answer for here and there. I just want to make sure that when we adjust this law, that we are adjusting it correctly. And yes, what you guys are saying is the fact that it's the owner, well, not the owner, the person that is subject to the order and in compliance with that order. So yes.
Thank you.
Representative Ray Newman.
Thank you. For my edification, could you just clarify how a person who has to drive with an interlocked device, how that affects their ability to drive and how the thing works when they have to use it?
The short answer, Representative, is nothing gets affected so long as they're not under the influence. The longer answer is how it affects their situation. They are subject to having to blow into the device prior to starting. They're also subject to a random rolling retest. And that's just to prevent the example of, okay, I'm sober now, but I got my six-pack ready to go here. They know that they're going to be subject to at any given time. So that's I guess to the extent of that's how it impacts them.
Representative Ray Newman, recognized for a follow-up.
Thank you. So is that information recorded somewhere when it happens that the person now has finished the six-pack and the car is then disabled, I understand, I assume.
So
And then is that information, who is that information available to, and how does that affect
Sure.
their situation?
Okay, so a couple of things. When there is a violation, it's everything's recorded, and it's, I believe the law says that it has to be sent in or transmitted in real time. That's for the enhanced version. So yes, there's a whole communication system set up between the various vendors and the department, so that there's violation reports and whatnot. You mentioned about disabling the vehicle. I want to be absolutely clear here that during a random rolling retest, when they're going down 93, the car isn't automatically disabled. It's what happens then at that point is if there's a violation, they need to turn over because there's a violation, the horn's blaring, and then there would be a lockout for a period of time.
Thank you.
If you may speak.
Sorry, thank you. Thank you again for the opportunity. So as I'm reading through this and taking into consideration the ideas brought forth, we want to make sure that the spirit of the ignition interlock is installed. So if we are proposing that after a period of revocation or suspension to install an ignition interlock device as defined in RSA 259-49A in any vehicle used by that person for not less than 12 months,
Representative Testerman.
If you install something for not less than 12 months, and that's outside the period of his sentence, is that the right thing to do? I mean, why are you leaving it on there? I'm not sure if I heard that correctly.
thank you for your question. That is just where I stopped reading in the statute. There's at minimum a 12-month compliance, and depending on violations, depending on the 24-month, depending on circumvention, it can be in a vehicle for a much longer duration. What's important is to recognize that a device must be installed in a vehicle that a person uses in order to be in compliance with the ignition interlock program. So while we are speaking about the driver specifically, there is a vehicle installation aspect to the ignition interlock program.
Thank you for your testimony. The chair may inquire with a question. Can you provide the committee any examples of what an aggravated DUI offense would entail?
Thank you for your question. An aggravated DWI offense would be somebody that had a blood alcohol, breath alcohol concentration greater than a 1.6. Legal limit is 0.08, aggravated would be 1.6. So, and out basically double what the minimum is. Also, if they tried to elude the police, was involved in a crash that resulted in bodily injury, any of those are aggravating factors which would then make it an aggravated DWI.
Thank you for taking my question. Representative Green?
Is there any, what am I trying to think of? Circumstances in like there where New Hampshire may remove a person's registration, their plates, and their license for a period?
Yes, there are a number of different scenarios that would allow the Division of Motor Vehicles to do that. There are a number of things that could occur, but yes, that is a possibility.
Okay, thank you.
Thank you.
Thank you for your testimony. Are there any members of the public who wish to testify that are present who have not testified already? Seeing no hands, at this time we'll now close the public hearing on House Bill 1085. The committee will be in recess to 10:45.
Quiet, please. We're going to open the public hearing on House Bill 1333 FN. We ask the prime sponsor, Representative Abbas, to introduce the bill.
Thank you, Mr. Chairman. My name is, I'm Representative Darrell Abbas. I represent Rockingham County District 8. And this for the members who served on the committee last term with myself. This bill actually passed in committee with a positive recommendation. However, it was unceremoniously tabled over my objection. So I have now refiled the same exact bill. When you turn on the news, sometimes you'll hear a news report about someone who's been arrested and convicted of their 5th or 6th drunk driving conviction, and people always wonder, how does that happen? How does this person still have a driver's license? In New Hampshire, when a subsequent offense is prosecuted, there's a look-back period. The look-back period for all the offenses is 10 years. So the 3rd, 4th, 5th offense would all have to happen within a 10-year time period. What this bill would do, it simply would extend the look-back time period for the 3rd and 4th offenses. The rationale for that is quite often the 3rd and 4th offense don't occur within the 10-year window. And during that 10 years, especially for someone who's been now convicted 2 times of drunk driving, that person's license has been suspended for a large portion of that time period. So this is really addressed to repeat offenders, specifically 3rd and 4th offenders, and it would just simply extend that look-back period in that limited circumstance. It does not prevent someone from obtaining an annulment of a conviction, which is a 10-year time period for any drunk driving conviction. And if a person were to get a conviction annulled, it would not necessarily mean that wouldn't count towards the subsequent offense. So that was the purpose of this bill, was really to address repeat offenders, and we're talking 3rd and 4th offenders, not 1st and 2nds. And personally, the way I look at it is, if an individual is continuing to break the law, especially commit the same offense that they've already been convicted for on 2 occasions, one, that person is engaging in behavior that creates a risk and danger to public safety. At the same time, it also shows that person has not been rehabilitated at all by the punishment or penalty for a 1st and 2nd offense. So I would hope it passed in the committee last term. I hope again it passes this term. I hope it passes in the House and no one makes a motion to table it. And I'll of course answer any questions.
Representative True.
Thank you, Mr. Chair, and thank you for taking my question. Do you have the House bill from last year?
I was in the process of looking that up. If you give me about 15 seconds, I'll tell you right now.
Thank you.
The House bill from last term was HB 1654.
Representative Bourdonnais.
Thank you, Mr. Chair. Thank you for taking my question. In your testimony, you said that if a conviction was annulled, then that would still count. How is that going to be counted? And I didn't see any reference in the language of the bill about annulment of convictions being an exception.
Last term, and I believe it was, if I'm going off of memory, but it was Senate Bill 311, and that as it came to the committee last term, it involved annulments of several different areas, but one of the sections of that bill was specifically drunk driving convictions, and that wanted to reduce the look back period. I shouldn't say look back period. The time period from the date of your conviction to when a person would be eligible to get an annulment. But in the language in the existing law is, if you get a offense, if you get an annulment of an offense, it doesn't necessarily negate it from counting as a subsequent, towards subsequent offenses. That's just what we were, what is, as written. Now, can you prove a subsequent, a prior offense when it's been annulled? That could be rather difficult. That can be challenging because you would have to prove the conviction, and if you don't have access to the records, it can be hard to do. There was some disagreement between myself and a well-known UNH law professor that frequents here very frequently. We disagreed on how that would be proven in a court of law, but that's what the look-back period. This wouldn't affect that by any means, and I'm not trying to address the annulment issue.
All right. Thank you. I have no further questions.
Representative Muse.
Yes, thank you for taking my question. Something I'm just interested in some clarification on is it appears at the bottom of the bill there's some language that would include an out-of-state conviction as one of the offenses that would qualify as a third or fourth offense. Is that true? And how do things like out-of-state convictions change with this particular bill?
So my understanding is that for the purposes of considering subsequent offenses, and specifically for drunk driving, it's the practice of the overall, I want to say every state will consider out-of-state convictions when it comes to whether it's a subsequent offense or not. For New Hampshire's purposes, again, we have a limited look-back period. Every state has a different look-back period. Some states have an unlimited look-back period. So this is really what this is focusing on is it can count out-of-state convictions, but I don't believe that would change the look-back period at all. It just, whether it's a second, third, or fourth offense, it would take into consideration out-of-state conviction. And a lot of driving laws will factor in out-of-state convictions.
So I guess just to clarify for me, because I'm less familiar with our drunk driving laws than I probably should be, but under current New Hampshire law, are out-of-state convictions actually counted as prior convictions? So, for instance, if we're looking at determining, let's say, whether somebody's been convicted 3 times, would a conviction in Massachusetts or Vermont count as one of those convictions that would trigger that part of our law?
My understanding is that the out-of-state conviction will be considered, provided it's the equivalence. So if the legal limit is 0.08 or higher, let's just say for the sake of argument, another state, their legal limit was 0.112. I think I have to go the opposite direction. My whole point is it would have to also be consistent with our laws. So if let's just say it was 0.06 in Vermont, which it's not, but let's just say that it is. If you got a drunk driving convictions and your blood alcohol content was 0.06, although you violated Vermont law, because it's not the equivalent of the New Hampshire law, my reading of this is that would not actually count as a prior offense because of the blood alcohol content difference. I'm not aware of any state that does not have 0.08.
Thank you.
Would it, question, wouldn't it, under the, I don't know if it's the equal protection, what is I forget, my constitutional law is failing me right now, but where we recognize the laws of other states, I believe would that not cover that?
I believe you're referring to the full faith and credit clause.
That's the one.
Without getting into that constitutional principle, it's very common that when it comes to drunk driving convictions that you factor in, you consider other out-of-state convictions, and that's something that a lot of the states kind of joined together as an issue of safety purposes.
Representative Bourdonnais.
Thank you, Mr. Chair. Thank you for taking my question again. I'm looking at line 1 on page 2, and says occurring more than 10 years after the date of the present offense. Isn't that, that's indefinite, isn't it? Well, should that be within 10 years?
Let me read it.
Sure.
Let me, if you don't mind, if I may read it, and if the
Ooh,
chair
go
will
for it.
so graciously let you ask the same question.
Page 2.
I'm on my way. Are you pointing out, is your question, is that a drafting error?
I'm asking if that's the intent or not.
I think it would have to be before.
So this is only for offenses after 10 years forever.
The intent is for that to be within the 10-year time period, not forever. I'm aware, and I'm very thankful that my friend from Keene was so kind to point that out. I'm even more thankful that he serves on this great committee with me, so we can work together to fix that. And actually, you know, I'll take the heat for this. I believe Representative Welch pointed this out last year, and it's the same as before. But I'm glad everyone was on their toes and caught that.
Representative Ray Newman.
Reference that same line. After it's corrected, and there is a penalty associated with that of a Class A misdemeanor. So if someone had a DWI offense, first offense in that time period, is that the same penalty, or it seems to be in bold, or has the penalty been changed? Do you know?
It's inquiring. It's dealing with a subsequent conviction. So that would be the second offense.
Okay.
Is what I understand, a Class A misdemeanor.
Thank you.
There being no further questions. Oh, there is one. Representative True.
Thank you, Mr. Chair, and thank you for taking my question. I believe you said that in New Hampshire, we already take into consideration out-of-state convictions when you're adding up the number of offenses. That being the case, why do we need Section B, page on line 28, if we already do that?
I think what this is doing, it's clarifying the look-back period. That's my understanding what the purpose of that section is. It's how far do you go back in time from one where you're going to consider a prior offense. So if you have a conviction, then 30 years later you get a second, that won't be considered. But I think when considering the out-of-state, you want to make sure the look-back period is the same.
Thank you.
There being no further questions. Thank you for your testimony.
Thank you, Mr. Chairman.
Anyone from the public who wishes to testify who hasn't signed up to testify? There being none, I close the public hearing. And now we have till 11:30. Could the chair please come to the... As we said in the military, assume the position.
At this time, we are now going to open the executive session on House Bill 1433, relative to penalties for poisoning dogs. For- That's the penalties for poisoning dogs. 1433. Does anyone wish to be recognized to make any motion? It's wide open for anyone to do. Oh, wow. And Representative Roy.
Yeah, I'd like to make a motion of inexpedient to legislate.
That has been seconded by Representative Burt. Does anyone wish to speak on the motion, Representative Roy?
Yes, if I recall from the testimony, this the intent is obviously great, but there was confusion about what constituted intentional poisoning versus accidental poisoning, whose property the poison was on. It was very complicated, and even speaking to law enforcement, it would be difficult to enforce as it was written. We already have felony animal cruelty statutes. If it should become necessary to actually codify poisoning as part of that, I think it needs to be done in a much clearer fashion than this bill presented. So at this point, I'm going to move inexpedient to legislate.
Seeing no further hands raised, we'll now move the question. If you are in support of the motion of inexpedient to legislate, please say yay. If you are opposed, please say nay. The clerk will now call the roll.
Vice Chairman Roy.
Yes.
Representative Welch. Representative Burt.
Yes.
Representative Rhodes.
Yes.
Representative Green.
No.
Clerk votes yes. Representative Testament. Representative True.
Yay.
Representative Pratt.
Yes.
Representative Marston.
Yes.
Representative Harriet Gathright. No, we can't. We're in the voting mode, please. Representative Sue Newman. Yes. Representative Jack.
Yes.
Representative Bourdonnais.
Yes.
Representative Muse.
Yes.
Representative Ray Newman.
Yes.
Representative Bolden.
No.
Representative Conley.
Yes.
Representative Bradley. She's not here. Representative Espitia.
Yes.
Chairman Abbas.
The chair votes yes.
17 yeas, 2 nays, 2 not voting.
I think Representative Marty Representative Marty Jack is in for Amy Bradley, right? O'Hearn, sorry.
Yep, he voted yea.
He voted yes.
Sorry, I apologize then.
Correct, you voted yes? Very good.
So it's 17 to 2 is the vote. Move for consent, anyone?
Yes. I move for consent.
Will there be a minority report? Majority report?
Yeah, I'll do it.
Thank you, Representative Roy. This time we'll now close the executive session on House Bill 1433.
Majority ITL report. Thank you. Mushrooms.
We need, where's David? I think he walked down to the. At this time, we will now open the executive session on House Bill 1349, decriminalizing the possession and use of mushrooms.
Is it the right one?
Representative Conley, you wish to be recognized to make a motion of inexpedient to legislate?
Yes, Mr. Chairman, I would make that motion.
All right, yeah, no, we can, Representative Herrick, I understand, I appreciate the comment. There is no list of what order we're going in. I kind of just look at the clock and try to gauge on what we can get done before the next hearing, so we don't have members of the public waiting. So we'll give a minute for everyone to pull up HB 1349. Who seconded the motion of Representative Roy? Seconded. Representative Conley, do you wish to speak on the motion of inexpedient to legislate?
Briefly, so I think like many people in the committee, I didn't have a great background or knowledge of psilocybin mushrooms, and it sounds like there really are some true medicinal benefits to this. That said, I think we're not there yet. I think there's a lot of questions that committee members might have, and especially in a state that hasn't yet decriminalized or hasn't yet legalized cannabis, this might just be a tad too far too soon.
Representative Harry Garrett, recognized.
Thank you, Mr. Chair. For whatever reasons, and maybe it didn't happen, I wrote on here study committee. Was this supposed to go to study committee? I'm just asking a question. I don't know why I made that notation on my sheet. So I'm just asking a question.
There was an amendment that was floating around. Obviously, it's not, but it was my understanding that amendment was not germane to the bill. And that amendment really was focusing on more of the issue of medical use, which that's a separate subject altogether. That policy's really outside the purview of what we would do here in criminal justice public safety. My feeling on that subject is that in order for this committee to do its due diligence in evaluating a penalty, you would need to first master the medical policy that you would put in place. So I think we would be this is my opinion. that it would need to pass the other committee first and then come this direction.
Okay.
Considering it was a non-germane amendment, the other committee was free to take up that issue at any time on their own without any comment or influence from this committee. So
Thank you.
I tend to agree that this is really to decriminalize the possession, and I think that's a conversation that we're going to have in the state, but I think with cannabis moving forward, it might be too much too soon. And I would say if we don't have a cannabis policy in place, at least, you know, recreation, I don't see this making it very far. I think it's raised enough awareness, got us all thinking, but in this bill, I think this bill will be back.
Okay. Thank you.
Representative Muse?
Yes, I plan to support the ITL motion. But my preference would have been for interim study. I feel that while there were some really good objections raised by folks like the state police, there was also a lot I learned at that hearing about the potential therapeutic use of this particular chemical, and I would like to keep it on the committee's radar with an interim study recommendation, but lacking that, I will support the ITL.
Representative True?
Thank you, Mr. Chair. Looking at page 2, around line 17, section D, are there any states that do give a medical card for psilocybin? That's what that section is referring to.
I'm not prepared to I couldn't answer that.
I don't recall any testimony at the hearing to that effect.
Seeing no hands raised at this time, we'll now move the question. If you're in support of the motion of Inex being to legislate, please say yay. If you are opposed, please say nay. The clerk will now call the roll.
Vice Chairman Roy.
Yes.
Representative Welch. Yes. Representative Burt.
Yes.
Representative Rhodes.
Yes.
Representative Green.
Yes.
Clerk votes yes. Representative Testerman.
Yes.
Representative True.
Nay.
Representative Pratt.
Yes.
Representative Marston.
Yes.
Representative Harriet Gathright.
Yes.
Representative Sue Newman.
Yes.
Representative Jack.
Yes.
Representative Bourdonnais.
Yes.
Representative Muse.
Yes.
Representative Ray Newman.
Yes.
Representative Bolden.
No.
Representative Conley.
Yes.
Representative Bradley. Representative Espitia.
Yes.
Representative Abbas.
The chair votes yes.
18-2. 2 not for.
Anyone wish to move for consent? So moved. Will there be a minority report?
So what did, you said two, true, okay. I had true as yes, okay.
Will anyone be doing a minority report? Representative Conley, will you do the honors of the majority? At this time, we'll now close the executive session on House Bill 1349. Yeah, we might be. I might exec one more now.
Mr. Chairman.
Representative Burt?
I was just wondering if you've heard anything about Friday. I know it's a shocker, but I think we're going to get some snow in New Hampshire. So, and I have a subcommittee, and I would love to attend it, but I know they like canceling stuff.
My understanding is that all the subcommittee hearings on Friday will be canceled.
Thank you for telling me.
So what I would recommend for any of the subcommittee hearings, the next date we'll be here would be the following Wednesday. And if anything, want to put those on in the morning. And I would say any bills that we have not held an exec on by the end of the day today, will likely be. Well, and I understand that. At this time, we'll now open the executive session on. It's at 11. The next hearing, public hearing, is scheduled for 11:30. So we have. Well, I have 3 minutes, but. At this time, we'll now open the executive session on CACR 34, the use, the sale, or cultivation of cannabis. Representative Testman, do you wish to be recognized to make a motion?
Second.
That has been seconded by Representative Roy. Representative Testman, do you wish to speak to your motion?
I can't hear him.
I'm not sure we have a lot of other agricultural things in the Constitution.
Any other members wish to speak? Representative Muse?
I intend to support the ITL motion as well as the ITL motions for the other cannabis constitutional amendments. I don't feel that the use of cannabis arises to a constitutional issue. I think our Constitution is for more critical things, and the regulation of cannabis should be a matter for the legislature to decide, and I don't think we need to put this issue in front of the people.
Seeing no hands raised, excuse me, Representative True.
Only because I think it's time we stop pussyfooting around on cannabis. I will support the constitutional amendment, the proposed constitutional amendment. Let the people decide. I don't see any harm in that. I think there's probably a lot of opposed constitutional amendments having to do with this. Maybe that's too many for the people to decide on, but that's up for the people to decide if they don't like the speed that the legislature is moving at. Thank you.
Seeing no hands raised, at this time the matter will now move the question. If you're in support of the motion of Inix being to legislate, please say yes. If you are opposed, please say no. The clerk will now call the roll.
Vice Chairman Roy.
Yes.
Representative Welch. Yes. Representative Burt.
No.
Representative Rhodes.
Yes.
Representative Green.
No.
Clerk votes no. Representative Testerman.
Yes.
Representative True.
Nay.
Representative Pratt.
Yes.
Representative Marston.
No.
Representative Harriet Gathright.
Yes.
Representative Sue Newman.
Yes.
Representative Jack.
Yes.
Representative Bourdonnais.
Yes.
Representative Muse.
Yes.
Representative Ray Newman.
Yes.
Representative Bolden.
I'm sorry, is the motion ITL?
Correct.
No.
Representative Conley.
Yes.
Representative Bradley. Representative Espitia.
No.
Chairman Abbas.
The chair votes yes.
"13 yeas, 7 nays, 1 not voting."
Will there be a minority report? Representative True? Representative Green, you wish to do the minority report? No. Will there be a majority report? Anyone? Representative Testament, you wish to do the honors? Thank you. At this time, we'll now close the executive session on CACR 34. At this time, we'll now open the public hearing on House Bill 1145, relative to a motor vehicle exception to criminal restraint or false imprisonment, and relative to civil immunity and physical force in defense of a person. And I believe that the sponsor of the bill is unavailable, so if there's any member that would simply just introduce the bill, no testimony necessary. Representative Byrd, if you don't mind. Thank you. Without spoiling the potential testimony, I will say the sponsor of the bill did send an email requesting that this bill be inexpedient to legislate.
Thank you, Mr. Chairman and fine committee members. I am Representative John Burt, Goffstown, Ware, and Deeren. I am opening House Bill 1175, and if you could hold all questions to somebody else. Oh, 45, sorry. Let me correct my eyes. 1145. Thank you.
Thank you, Representative. You are excused.
The committee now calls Penny Dean.
Oh, it should be red? Oh, yeah, guess so. I'm used to the opposite, so sorry. Thank you. My name is Penny Dean. I'm an attorney licensed in Maine, New Hampshire, Massachusetts, admitted to the federal courts, D.C. Circuit, Supreme Court, United States Supreme Court, and several other courts. And I see this as an anti-self-defense bill. Basically, one of the worst parts of it is line 22A. Basically is trying to remove the limited stand your ground protection New Hampshire has. New Hampshire truly doesn't have stand your ground protection. It should have, but it doesn't. But this, by or anywhere he or she has a right to be, by striking out that provision of 627(1)A and 627(4)(3)A, basically removes tons of self-defense protections that we do need. We actually need more in this state. And I respectfully would say that alone should be enough to ITL it, but it sounds like we're already there. I just have seen bills flop and take different procedural paths, and I want to make sure that this bill hopefully is dead on arrival. There are many other provisions in it that are problematic. And if you look at 627(1)A, which is found on line 12 of the first page, they want to remove protection of premises and property pursuant to 627(7) and 627(8). I guess that means burglars can come in your house and tear things apart and maybe tear you apart, and hey, you can just leave your house and let them have at it. And I don't think that's where we want to be, because anybody who is so crazy to break in your house or come in your house, in addition to tearing your property up, your body may be next. And so I'm happy to answer mechanical questions, but here's the thing that the committee has to know, and this is something that as a trial lawyer frustrates me and just brings me to tears actually. Whether or not a trial judge will allow an affirmative defense of self-defense to be raised is totally up to the trial judge. People think that you can raise it. Yeah, your lawyer can raise it, you raise a motion, you bring up the facts, but the trial judge determines whether or not that's actually going to be raised or heard by the jury and to what level. And that's a really, really big deal if you're the one sitting in the defendant's chair. The other issue is whether or not there's going to be any further protections added, because here's the thing that you have to remember. In this state, we do not elect judges, and that's a big deal. Trial judges in the majority of states in this country are elected, which means you can unelect them when they don't follow the Constitution and the laws. And so you have to think about that and ask yourself, walk into a half a dozen courtrooms and watch and ask yourself if you would want to be tried with your freedom and life on the line in front of a particular trial judge and know they're there for life, pretty much until the 60s. And I'm happy to answer any practical questions of how this works.
Seeing no hands raised, I want to thank the witness for her testimony. And the witness is excused.
Thank you. Do you want me to undo the red button here? Okay.
Thank you, Attorney Dean.
Are there any members of the public present that wish to testify that have not testified already? Seeing no hands raised, at this time we will now close the public hearing on House Bill 1145. At this time, we will now open the executive session on House Bill 1145. Does anyone wish to be recognized to make a motion of inexpedient to legislate?
Yes.
Representative Burt, you are recognized.
With prejudice.
I'll make a motion to Thank you, Mr. Chairman. I'll make a motion to ITL.
Second.
That has been seconded by Representative Harriet Gathright. Representative Burt, you wish to speak to your motion?
Yes, Mr. Chairman. Thank you. Attorney Dean, when she spoke, said it exactly what I was going to say. You know, it just removes too much for New Hampshire, really any state. So the person has a right to defend themselves if a burglar breaks into the house. And that's it. You know, we need those protections. This bill would remove them, and that's why I support the ITL and made the motion.
Representative Muse?
While I'm peeved that the sponsor declined to show up, I support the intent of the bill because basically I did not support the expansion of Stand Your Ground in other sessions of this committee and did not vote for it when it came up before the legislature. This would unwind it, and I support it. But I do not support the ITL. Thank you.
Representative Harriet Gathright?
I just wanted to say that I too like the bill, but out of respect for the sponsor and the letter that he sent us, I am willing to ITL.
At this time, we'll now move the question. If you're in support of the motion of Inix being to legislate, please say yes. If you're opposed, please say no. The clerk will now call the roll.
Vice Chairman Roy.
Yes.
Representative Welch.
Yes.
Representative Burt.
Yes.
Representative Rhodes.
Yes.
Representative Green.
Yes.
Clerk votes yes. Representative Testerman.
Yes.
Representative True.
Yes.
Representative Pratt.
Yes.
Representative Marston.
Yes.
Representative Harriet Gathright.
Yes.
Representative Sue Newman.
Yes.
Representative Jack.
Yes.
Representative Bourdonnais.
Yes.
Representative Muse.
No.
Representative Ray Newman.
Yes.
Representative Bolden.
Yes.
Representative Conley.
Yes.
Representative Bradley. Representative Espitia.
Yes.
Chairman Abbas.
The chair votes yes.
With a vote of 19 to 1, the bill is ITL.
Mr. Chairman, I'll do a majority report, and I would like a consent if we could get it.
Thank you, Representative Burt, and thank you for volunteering to do the majority report. Will they be a minority report? And move for consent, Representative Burt?
Yes, please.
Thank you. This time, we will now close the executive session on House Bill 1145. At this time, the committee will be in recess to
The next one's 1:45. Back at 1 o'clock.
Yeah, 1 o'clock.
Gives us an hour for lunch.
Yeah.
the committee will be in recess till 1 p.m.
Sounds fine.
At this time, we're now, the Criminal Justice Public Safety Committee will come to order. At this time, we will now open the executive session on House Bill 1108. 1108?
I'm shocked.
Also known as the Barney Bill.
I'd like to make a motion.
Representative Eric Gathler, we have now opened the executive session on House Bill 1108. We have been referring to it as the purple paint bill. I do not have a copy of the bill in my binder. Representative Muse? Well, I believe Representative Harriet Gathler was going to make a motion of inexpedient to legislate. Or Representative Burt, excuse me.
Yes.
Representative Burt, you have been recognized to make a
Thank you, Mr. Chairman, and I make a motion of ITL and expedient to legislate.
Is there a second? That has been seconded by Representative Harriet Gathright. Representative Burt, do you wish to speak to your motion of inexpedient to legislate?
Yes, I would, Mr. Chairman, and thank you. Mr. Chairman, we heard testimony from Forest and Lands, New Hampshire Forest and Lands, New Hampshire Timber Lands Association, New Hampshire Fish and Game, which all oppose this bill. They said they have tried it up in Maine and it has failed. You know, matter of fact, one person said that it seems like there's more people hunting on the partials that are painted purple because people don't understand in this area. The biggest thing, you know, to what purple means, the biggest thing that I'm opposed to this is New Hampshire and pretty much New England is unique. We have, it's called, if I get the word right, common land. So you could own 500 acres or 1,000 acres or whatever it is, and your neighbors can just walk on it. Now, if you want to post it, you can, but I kind of like the way it is. Because, you know, down south in some of the states, and I understand also a little bit out west, you know, some states, you know, it's pretty much, it's not, everything is posted even without signs, so you have to get permission. Where, you know, this came from, you know, when England, we came over from England and we started moving around, this is just stuck for hundreds of years that allow us to walk on somebody's property that is not posted, you know, without trespassing. And I think this bill would just cloud up the current situation we have, which I support, and I hope you support the ITL. And again, you know, there was 3 major landowners groups that, you know, oppose this. And I just see no value in this bill, so I hope you support the ITL. Thank you.
Representative Bourdonnais?
Thank you, Chair. I'm going to oppose the ITL motion. I think that the amendment that we have not heard and produces a hybrid posting, which would make it easier for some of our landowners to do and maintain. So for that reason alone, I consider it an advantage for property owners that want to post their land. I was not happy with part of the amendment that was offered by Representative Roy, and that was because of the penalty was a felony, and I did not like that. But I think that this has has merit. It would allow posting of land in the current way, but not as frequently as every 100 yards, but except for using purple paint. And the posting of today would be every 250 yards. So I think that this bill has a lot of merit, and I'm not going to support the ITL. Thank you.
Representative Roy.
Thank you, Mr. Chairman. I would like to associate myself with the remarks of my good friend, Representative Bordenay. I think that there is my constituents who are landowners. I represent Deerfield, Nottingham, Northwood, Candia, and soon Auburn. They own a lot of property. Some of them are senior citizens, and they just see some merit in not having to either hire somebody or find a way to get around their entire acreage every year to replace damaged signs. And like I said, my constituents have asked for it, and I am here for no other reason than to represent them. So I am advocating for this bill to not be ITL'd so that another motion could be made.
Representative Harry Gathright.
Okay, one of the, thank you, Chair. One of the things that helped me with this is a document that we received from the Division of Forests and Lands. It was Patrick Hackley, Director of New Hampshire Division of Forests and Lands. And he says that the purple boundary paint to indicate no trespassing is an uncommon practice in the Northeast and is not widely recognized by the majority of the landowners, foresters, surveyors, and forest recreationists. Posted signs are well recognized and can be easily added or removed as landowners desire or ownership change, as opposed to essentially permanent paint markings. He also goes on to say that there are well-established, time-tested standards for boundary markings used by licensed surveyors and foresters that are more effective than those proposed in this bill. So, with that said, I agree to the ITL.
Representative Conley.
Thank you, Mr. Chairman. I'll be opposing the ITL. So traditions are important. The tradition of allowing anyone onto your land unless it's posted, that goes back a long time. One thing I think is one of many things that trump tradition are property rights. Property rights. So this is the current tradition is a diminishment of property rights. It tells a landowner they must do something, incur a cost, or anyone can access their property at any time. This bill, purple, green, orange, whatever color, I would expect a hunter to know what that means if the law were to change. It's not onerous, and property owners should have choice in how they mark their property. Thank you.
So I'm just going to read from this. The irony, it's a purple book, but this is what we have here. And I'll just explain that when you're dealing with criminal trespassing, a person is guilty of criminal trespass if, knowing that he is not licensed or privileged to do so, enters or remains in any place. So knowingly, a person acts knowingly with respect to conduct or to the circumstances that is a material element of an offense when he is aware that his conduct is of such a nature or that such circumstances exist. So in order to, it's one thing to have the purple paint essentially replace the no trespassing sign. The person would have to know what the purple line of paint means. And I said this earlier today, some of the members here privately, that this is one of the few policies that I believe the state would be better served being one of the last states to do it. Because the enforceability side, if a person does not know what that means, I mean, I don't think any of that defense would work with us because we're all here on the committee. But if you don't know what the purple line means, you can't prosecute it, you can't enforce it, and we heard that was a problem in Maine. And the way New Hampshire's law is now, if your land doesn't say no trespassing, people are free to enter it for hunting purposes. Now, it's common practice that hunters will generally talk to the landowner, but it's not a requirement. At least I'm not aware of it being a requirement. So I'm just explaining that for me, this is really an enforceability side. The policy itself is not the issue. And then there's no restriction on the type of paints you use. There can be environmental issues with that. There's just things to think about. And this will be back because, like I said, I think New Hampshire's better served being on the back end of this, not the front end. I don't see this being a huge problem in the state that we're fixing or solving by passing this. So frankly, I'll be honest, I would have no idea, if I did not sit on this committee, I would have no idea what the purple painted tree meant. So, and that defense would actually work, because I'm not aware. So, and once someone explains you, it's different. So the other part of it is you can grant people access. It's kind of hard to remove the purple paint where the sign's easy to remove. So there's that problem too, once it's on the tree. So I will be supporting the motion of any expedient to legislate, and I hope and welcome my friends to join me. Representative Roy.
Thank you, Mr. Chairman. I would just a couple quick points. As far as education, it's a matter of when you renew your hunting license, having a slip of paper that explains the purple paint. As we all know, ignorance of the law is not an excuse to break the law. Furthermore, there'd be enormous press coverage. It would be well known to the public. But having said that, also from an enforceability standpoint, many laws we change every year don't necessarily make it to the public's at large view for a while. I mean, if we took that tact with every law we pass, we might as well never pass a law because nobody would know about it. So I don't think that's a good argument against it. I think that the compromise was good. I think it helps homeowners. And again, I would reiterate my request that the ITL fail. Thank you.
Thank you, Representative Roy.
Thank you, Mr. Chair.
Representative Bourdonnais.
I just wanted to point out one thing. The purple paint doesn't mean anything without the traditional posting. So if you take the landowner decides that, hey, you know, the hunters are okay, I don't mind people trespassing on my property, all he has to do is take down the traditional posting, because the purple paint doesn't mean anything without the traditional posting. So I think it's a great idea. Thank you. Fine.
Can I ask, though, if you have the traditional posting, why do you need the purple paint on top of that?
Is that a question for me?
Yes.
Because it's easier to execute, and you don't have to execute it on an annual basis. So it's cheaper for the property owner to carry out, and it's easier.
But what I'm saying is, if you need the purple paint, and you have to have the traditional posting, by having the traditional posting already, wouldn't the purple paint not be necessary because it's already traditionally posted?
Okay.
It's a question.
As Representative Roy presented, the hybrid system is a traditional posting every 250 yards instead of every 100 yards. It is a lot less work, but it is still work. Now, posting with a purple paint every 100 yards, in addition to posting on the traditional posting every 250 yards, is less of an issue, a problem. So I'm going to maintain my position.
Representative Burt.
Thank you, Mr. Chairman. And ever since I guess we're leaning toward talking about I guess we are talking about the amendment, if this failed. The amendment does not say spray paint purple paint or a no trespass sign and/or. You know, so if the purple paint's there, it's still no trespass. You can take your signs down, but it's still no trespass because it doesn't specify either or, in my eyes. But then also, a second offense of spray painting a tree that is not yours is a felony. I can't imagine anybody's gonna vote for a felony charge on a second offense when you go down in Manchester and you see all the buildings graffitied and billboards are graffitied on the back side of them, and the fence, you know, the big interstate fences, they're graffitied. I don't think they get a felony for the second, third, fourth time they get stopped or get caught doing that. So I think the crime way more outweighs, you know, the punishment outweighs the crime. You know, is it wrong to spray paint trees that aren't yours? Yes. But a felony charge, you know, I just can't go for that. So I'm still sticking to my ITL.
Well, traditionally, when you recognize someone to speak, you're supposed to let someone who hasn't spoken already yet. That's why. Representative Ray Newman, if you.
Thank you. I wasn't keeping adequate track of who had spoken first. I want to say that I agree with my good friend John Burt down there about the felony crime. I'm just not in favor of that. And the other thing is that I'm finding it difficult, and I assume we are talking about the amendment that was passed out this morning, and that's where it is, and there's no subsequent amendment forthcoming. So I am confused by the wording in section 1 on where they go and how you put them out and that kind of stuff. So I will vote yes for the ITL.
At this time, I will move the question. If you are in support of the motion of inexpedient to legislate, please say yay. If you are opposed, please say nay. The clerk will now call the roll.
Vice Chairman Roy.
No.
Representative Welch.
Yes.
Representative Burt.
Yes.
Representative Rhodes.
Yes.
Representative Green.
Yes.
Clerk votes no. Representative Testament. Is that your final answer? Representative True.
Yay.
Representative Pratt.
No.
Representative Marston.
Yay.
Representative Harriet Gathright.
Yes.
Representative Sue Newman.
No.
Representative Jack.
Yes.
Representative Bourdonnais.
No.
Representative Muse.
No.
Representative Ray Newman.
Yes.
Representative Bolden. Representative Conley.
No.
Representative Bradley. Representative Espitia.
Yes.
Chairman Abbas.
Chair votes yes.
12 yeas, 7 nays, 2 not voting.
Mr. Chairman, there will be a majority report, and I doubt I can get it on consent, could I?
Will there be a minority report? No. No. By a vote of 12 yeas and 7 nays, the motion of inexpedient to legislate passes. Representative Conley, you'll prepare the minority report. This time we'll now close the executive session on House Bill 1108. Just to give everyone a little roadmap, we're going to now open the executive session on House Bill 1512. But after this one, the next two will follow be CA CR 20 and CA CR 35. So just get those ready as well. So we now, we've now opened the executive session on HB 512. That's relative to the parole of certain 1512. Excuse me. 1512. Representative Roy, you wish to be recognized to make a motion?
I would move ITL on HB 1512.
Is there a second? Has been seconded by Representative Conley. Representative Roy, do you wish to speak to your motion?
I was actually going to, but Representative Burt said that he wanted to speak on it, so I'm going to go ahead and let him have it.
Representative Burt, you are recognized to speak.
Thank you, Mr. Chair. The testimony we heard just pointed out that this is not a good bill, and I'm going to live by those words and vote for the ITL.
Thank you, Representative Burt. Will anyone else wish to speak? Representative Bourdonnais.
Thank you, Mr. Chair. Yes, I'm going to oppose the IT motion. I think that people in prison have an opportunity to change their life around. 25 years is a long time, and it is possible for prisoners to become new people. And I think that they should get a chance to have a parole review after 25 years, or even sooner, but 25 years is plenty. Thank you.
And I'm just going to make a general point. It applies to this bill, but if you look at lines 1 through 24, although without even evaluating or taking a position what those points made, those factual points and factual statements have nothing to do with the subject matter, what the bill is trying to accomplish. I would just recommend anyone putting bills in to not have unnecessary language like that, because you may lose support on language like that. But ultimately, I'm not sure how much you'll gain. That's really the argument to pass it. Shouldn't be written in the law. Just a thought. But anyway, Representative Roy, you wish to speak?
I do, thank you. I would agree with Representative Bourdonnais in as much as I agree that that people incarcerated definitely deserve a second shot in a review, and 25 years is a long time. However, the sponsor of this bill did not coordinate, in my opinion, with the Department of Corrections, with the parole board, in such a way as to get them their buy-in, or at least their understanding of what he was trying to do with it. And we heard from the parole board, we heard from the Department of Corrections. It's a logistical nightmare waiting to happen. I think that legislation accomplishing this end, and maybe even perhaps more, is far overdue. But this is not the vehicle for it. And I'd be happy to co-sponsor with anybody next session something that would accomplish the similar with the buy-in and with the cooperation of all the stakeholders. But I can't support this bill as written. Thank you.
Comment.
Representative Testerman?
I've heard several bills regarding parole in my time here, and I just get the feeling that we're not supporting the parole board enough. We have rules that countermand each other. They're understaffed. And I'll go along with the ITO because I think we need to do something about the parole board in particular. I think they're working hard, but I don't think it's doing a service to the citizens of this state, regardless of what it does for the prisoners.
Seeing no hands raised at this time, we'll now move the question. If you're in support of the motion of inexpedient to legislate, please say yes. If you're opposed, please say no. The clerk will now call the roll.
Vice Chairman Roy,
Yes.
Representative Welch,
Yes.
Representative Burt,
Yes.
Representative Rhodes,
Yes.
Representative Green,
Yes.
Clerk votes yes. Representative Testerman,
Yes.
Representative True,
Yes.
Representative Pratt,
Yes.
Representative Marston,
Yes.
Representative Harriet Gathright,
No.
Representative Sue Newman,
No.
Representative Jack,
No.
Representative Bourdonnais,
No.
Representative Muse,
No.
Representative Bolden. Oh, excuse me. Representative Ray Newman,
No.
Representative Bolden,
I'm sorry, can you remind me of the motion? Is it ITL?
ITL,
No.
Representative Conley,
Yes.
Representative Bradley, Representative Espitia,
No.
Chairman Abbas.
The chair votes yes.
12 yeas, 8 nays, 1 not voting.
By a vote of 12 yeas, 8 nays, the motion of inexpedient legislate passes. We had, it was not the exact same, but we had a similar bill last year that we made a similar recommendation on. However, we didn't, it was been refiled. It was not ITL'd on by the House as a whole. We had the same bill last term as well.
Before this committee as well.
Yes. Will there be a minority report? Representative Harriet Gathright will be doing the minority report. This time we'll now close the executive session on House Bill 1512. At this time, we'll now open the executive session on CACR 20. Yes. This is relating to personal liberty, that adults shall have the right to possess cannabis for personal consumption. Representative Testerman, do you wish to be recognized to make a motion?
Wait a minute, I thought this was 10:45 after.
What? Who are you?
Not quite, Ken.
We haven't opened up your hearing yet. I'm sorry.
No,
It says your hearing 10:72.
no, we are currently in executive session for CACR 20. And Representative Weil, I assure you, I did not park in your parking space today.
But will you start at 1:45 for 10:72, because I have it 2 o'clock?
Yes. That is the goal.
Very good, thank you.
Representative Testerman, do you wish to be recognized to make a motion?
I'll make a motion of ITL because we've got too many of these cannabis bills in the works right now, and we need to have only one and see what happens with that.
Representative Roy?
Thank you, Mr. Chairman. My opposition to this bill has more to do with the
Did Representative Roy, did you second the motion?
Yeah, sure,
All right. So that's what's just,
I think.
all right, let me correct myself. The motion was made of an expedient to legislate by Representative Testament. Representative Roy, do you wish to second that motion?
Yes,
My apologies. Representative Roy, you may continue.
no problem. Thank you. My opposition is more related to the fact that, again, it's a CACR. I agree with what Representative Muse said earlier, that constitutional amendments are much more serious and far-reaching than, especially than simple, agriculture issues. Specific plants, I don't believe belong in the Constitution. I also agree with Representative True that the people should decide. Having said that, we can't put every single thing in front of the people to decide. That's why they sent us here as kind of goalies to screen some of this stuff. And I think we do have several bills in front of the House and some in the Senate dealing with this same subject. And I just don't think that the opening the Constitution is a place for this. So I support the ITL.
Representative Conley.
Thank you, Mr. Chairman. I agree generally with what Representative Muse said with the last CACR as well, although that one had problems that I won't get into. But we have bills before the House. They're going through the process, and we know that process tends to run into hurdles in the other chamber. We don't know what's going to happen with this bill, but if we are going to bring a CACR forward, I would recommend this as the simplest one. This was written by the Democratic leader, the former chair of this committee. It's extremely simple in its purpose, and it would provide this legislature in the next term with a clear mandate to get this passed. Doesn't stipulate how it would come forward. It would still come before the legislature. And given the track record of the other body of to borrow a phrase, playing goalie on cannabis bills, I think that this would be something that we could get before the people, get it on the record, and get this chamber to finally move forward with some action.
Representative Burt.
Thank you, Mr. Chairman. Mr. Chairman, I will be supporting the ITL of this bill. I believe in letting the voters have the option, and we've already done that with CACR 34. I did vote against the ITL on, I believe it was ITL on that motion, but this motion I will support because we already gave them an option on the CACR 34.
Just to clarify, what this would do, all adults shall have the right to possess cannabis intended for their personal consumption. Now, on the way as written, whether you support recreation or not, you can have 200 pounds as long as it's intended for personal consumption. This would basically, yes, it's very simply written, but it would basically bar virtually any type of regulation for it, at least the way I read it. This is something that will be subject to court interpretation. Now, I could be wrong. People may not agree with that. But all adults have a right to possess cannabis intended for their personal consumption. I don't see there's any room for any capacity limit or possession limits on that. Whether it's growing, I mean, you wouldn't need a THC levels. I mean, even if you did make a personal consumption of people, different individuals have take different amounts to have different effects. It seems just how do you establish the intent? I mean, so you can sometimes use a large quantity of possession with intent to distribute. I get that, but it seems to me that this is going to be something that will be drawn out in the courts for a while, for better or for worse. Representative Wallace.
Thank you, Mr. Chairman. Just Article 2A doesn't have any kind of restriction on how many firearms or how much ammunition an individual can possess, and it's for personal consumption, is it not?
Well, Article 2A is the right to bear arms to protect yourself, your family, your property, and your state. So it's describing what you're bearing arms to do. I'm just saying this is.
And it does not mention how many you may or may not possess, or what type, or what power, does it?
No, and
Thank you.
there is no restriction on that. So you can own as many firearms as you wish. And my point is that this would also apply to cannabis in the same way, for better or for worse. I'm not just as it's written. That's how I would read it, and it would make regulating very difficult. That may be accurate. Representative Harry Gathright.
Thank you, Mr. Chair. When I look at this and it says adults, I'm assuming that is 18 years and older. I'm going to say to the committee, let's not forget what effect cannabis has had on the younger generation, particularly those between the age of 18 and say 25, and how many of them have ended in the mental ward because of cannabis. So I really think when we're talking about this, that we really need to be very clear about the age limits that we want to do cannabis with, or say that it's legal to do. That's my spill.
Representative True.
Thank you, Mr. Chair, and I'll be brief because I don't want to bogart anyone's important time. But the one we just voted on, CR 34, that ITL'd, so the people aren't going to have a vote on that. This one is a simple possession. I don't understand the worries about maybe you have 2 ounces or 2 pounds. There's no limitation on how much alcohol I can have in my house. Again, this is just let the people say what they want. That if the anecdotal tales that we have that the vast majority of the people are in favor of legalization, let's give them the vote. Maybe they're not happy with the fact that we're still dragging this issue out. That's why I cannot support the ITL. Thank you.
If I may inquire about this CACR, in respect to HB 5098, we just passed in the House by a vote 235 to 119. Ought to pass as amended. This CACR arguably would conflict with even that legislation. I'm just pointing that out. In my opinion, it would. I'm just don't. That's just the way I read it. Representative True, you may. You have an excited look on your face. I'm curious.
Yeah. No, if we legalize cannabis, we can't have any laws that conflict. It's just that it's legalized, and it wouldn't be we doing it. It would be the people doing it.
Correct.
We're representing the people now.
Representative Roy.
Thank you. Thank you. I just want to make one more point with the blanket legalization argument, is that if anyone of a certain age remembers the difference between cannabis today and cannabis, say, in the 1980s or 70s, what is going to happen with the genetic engineering of these plants in the future going forward? We have no idea. Cannabis could be infused with opium or bred with something else, and it would still fall into this. I feel like, again, making a blanket, it's okay, is opening Pandora's box. We don't know what's going to happen. And furthermore, this is still federally illegal. And if you want to bring attention, the feds have so far been staying at arm's length when states do these things. Well, the first state that's going to go ahead and say, well, we have no regulation whatsoever, come to New Hampshire and you can have all the pot you want, is going to draw federal attention. And every single person who has this is going to be prohibited from owning a firearm. There's all kind of implications. So it'd be great. We put in our Constitution, we can have pot, no problems. Well, every single person who uses it is in violation of federal law, regardless of what our Constitution says. So I just think that's important to note.
Representative Muse.
I just wanted to say that I have spoken in favor of cannabis legalization on the House floor multiple times, and I will do so again as long as it takes. But I do not think that a constitutional amendment is the right venue to take to make this happen. When I look at our Bill of Rights, I see natural rights, equality of men, the right of privacy, rights of conscience. I just don't think that cannabis is at that same level. And I think the best way to approach this is through the legislation that we have. Let's pass it. Let's convince the Senate to go agree with it and get the governor to sign it. And cannabis legalization will happen in New Hampshire. Thank you.
Representative Testament.
I think I heard something a few minutes ago. Representative Roy, did you say that if we legalize cannabis in this state, that those people who are using it cannot own a firearm? Oh, that's what I thought.
I believe it's if they regularly use it.
No, it says a user. Once.
The courts have interpreted that as a regular user.
I think it says
Ninth Circuit, though, that's not our circuit. But anyway, we don't need to get into that. We'll talk about that later. We'll talk in the office after. At this time, Representative Wallace.
Thank you, Mr. Chairman. And just if you haven't heard, Senator Schumer out of New York has actually asked a group of other senators and U.S. congressmen to put their heads together to duplicate what's going on in the states that have moved forward with legalization process. So, although presently that there's sound basis in that, the federal prohibition is not long for this country at this point in time, I would have to say.
Well, amen to that. At this time, we'll now move the question. If you are in support of the motion of inexpedient to legislate, please say yea. If you are opposed, please say nay. The clerk will now call the roll.
Vice Chairman Roy.
Yes.
Representative Welch.
Yes.
Representative Burt.
Yes.
Representative Rhodes.
Yes.
Representative Green.
Yes.
Clerk votes no. Representative Testament.
Yes.
Representative True.
Nay.
Representative Pratt.
Yes.
Representative Marston.
Yes.
Representative Harriet Gathright.
Yes.
Representative Sue Newman.
Yes.
Representative Jack.
Yes.
Representative Bourdonnais.
Yes.
Representative Muse.
Yes.
Representative Ray Newman.
No.
Representative Bolden.
Yes.
Representative Conley.
No.
Representative Bradley. Representative Espitia.
No.
Chairman Abbas.
The chair votes yes.
15 yeas, 5 nays, 1 not voting.
The motion of inexpedient to legislate passes. Will there be a minority report? Representative Bourdonnais?
We have 1 not voting. Representative Bradley's not present.
Representative Testament, would you be another majority report? No. They are very similar. You probably only have to change some minor words from.
You made the motion.
Thank you, Representative Testament. At this time, we'll now close the executive session on CR 20. At this time, we'll now open the public hearing on House Bill 1072, establishing a criminal penalty for denying an elected school district official access to any school district facilities, documents, or events. At this time, we recognize Representative Weiler to introduce HB.
Thank you, Mr. Chairman, members of the
1072.
committee, Representative Ken Weiler, Rockingham 13, the towns of Kingston and Hampstead. I'm personally acquainted with 2 incidents of a school board chair and a superintendent who overstepped their authority by denying the 2 people, one a document and the other access to school buildings. We need for there to be consequences for these abuses or they will just continue. It was expensive and a lengthy process for the person denied the document to go to court to prevail. A threat of misdemeanor might have produced the document sooner. In the case of being denied access to school property, the superintendent made up a charge of endangerment when the member contradicted his presumption that going outside to a portable classroom put students in danger. The member said, "I was trained as a sniper. If I wanted to harm children, it would be while they were on the playground." Superintendent overreacted and accused the member of dangerous and inflammatory statements and issued a ban on him being on school property. It so happens that the school property is where we go to vote. Was he denying him of his vote? I've heard of other instances of high-handedness of people whose positions went to their head and they took upon themselves powers that they did not possess. In most cases, the abuser had a conflict with the opinions of the abused party and was seeking some sort of revenge. The purpose of this bill is to keep discussions civil, so that no one tries some action that is inappropriate. This threat of misdemeanor will be seldom used, but should serve as a reminder that disagreements on policy should be resolved by a motion and a vote, not vindictiveness. Please support this proposal. Happy to answer any questions. Thank you.
Representative Rhodes.
Thank you, Mr. Chairman. Thank you for taking my question. So my understanding is that an elected school board official is elected for policies and financials of the district. So how would you propose if a school board member chooses that they want to see documents such as the benefits that a school employee has chosen, or an IEP of a student, or any other the confidential information, because it says here, shall not be denied access to any school facilities documents. So how would you propose excluding the documents?
If it was relevant to decisions they were going to make about finances and staffing and so on, you know, they may not be able to have it in a form that they could pass out to someone else, but they should be able to view it.
Representative Rhodes?
Thank you, Mr. Chairman. Are you aware that that a student's IEP is absolutely confidential information, and no school board member at any time has access to see that?
They may be looking at the costs and have things redacted that are confidential, but there should be an overall idea of what are we spending on special ed, how many students are involved, and what's the most expensive, and so on. And quite often, we hear about $200,000 being spent on special ed. Well, everybody's going to figure out who it is and wonder if there's some other alternative, and have people looked into the alternative. So there's things that they may need to know that could be redacted as far as identifying a specific student. And I know when we talk about the HIPAA, and I've gone to, when we're doing education and finance, and we say, you know, we need to know how many students are this and that, and their claim is, well, we can't give it to you because you would figure out which student it is, and that would betray confidential information. So, you know, there are some parts of it that can be revealed without, and I'm sure that they could use that argument, but once it's redacted and the gist of the information could be there for them to make policy decisions.
Representative Testerman.
Thank you, and thank you for answering my question. Are you aware that question? How do we audit you? Who audits you? You know, are these properly identified? And the answer was, well, we can't be audited. So, wouldn't I need access to some of these kinds of documents to determine if our special ed people are doing their job correctly?
I would hope that would be the case, because there's a lot of this under HIPAA and confidentiality, that a lot of information is withheld, not only from the public, but by the people on the policy-making thing. So I think that some of these things need to be re-examined. Just an hour or so ago, we were meeting on Legislative Performance Audit and Oversight Committee, and we were calling for an audit of the special ed. And we went over several of the things, and many of us had been involved in other committees previously on special ed spending. And we're going to wait for another scoping statement to come back from the audit division on looking at these sort of things. And it'll be interesting how much of this stonewalling we get. But we're looking at it from a kind of a high-level place. And what I do note, and they had not done a special ed audit since 1999, which is highly unusual that it goes that long. So in the interim, you and I have seen huge increases in staffing, which they're building their own empire under this guise of we can't expose this. So we may have later legislation to say, you know, within a certain realm of policymakers, yes, this can be exposed, but they would have to take an oath not to reveal it.
Representative Espedia?
I just want to thank you, Mr. Chair. I just want to follow up with your statement that you just made. So you believe that they're building an empire under the sun for special education? Some of the most vulnerable students that we have? Okay.
Yes, and we also discussed within that other committee what have been the results from the millions of dollars that all our taxpayers are paying, and yet we have people that get handed a diploma who can't read. So why wasn't that taken care of? So there's lots of failures in this whole system that I think that everybody needs to get a look at. And we're going to have an audit, and it's going to give us some further leading and where to go. Thank you.
Representative, thank you for your testimony, and the chair will inquire with a question, and thank you for taking my question. When an IEP is put together for a student, it's usually done in some team meeting setting where there's several, I don't know if stakeholders is the right term, but there'll be several people at the table putting it together, where the education plan is targeted for that individual student. So I suppose if you did audit it, I guess my question is, wouldn't the numbers constantly change based on how the IEP evolves as the child progresses through school, or once the child graduates, those numbers would be stale?
Granted, it's a snapshot of given time and place, but nevertheless, what did you spend this last year on? How many different students? And we just looked at, I think there was a list of 15 different categories that they could be put in. And, you know, multiple things. Obviously, blindness and deafness are fairly apparent. But then there's also, you know, a bunch of other things, nervousness and anxiety and all these things that, you know, in some cases when I visited charter schools, they had students, they pointed out to me they had 3 students that came there with special ed for anxiety. Once they were in the charter school, the anxiety went away. So, you know, sometimes these things need to be reassessed on a regular basis. So,
Representative Bolden.
Thanks for taking my question. I was wondering, the way that it looks like the way that this bill is structured, you want to guarantee access to the facility and records and staff, with the exception of people who are either being investigated for or have been convicted of certain crimes. Notwithstanding the fact that there are definitely lawmakers in New Hampshire who've been convicted of crimes but are not necessarily a threat at the time that they're elected, is there a reason that you excluded, because I looked at the list under RSA 189:13-A, I looked at the list of violations in the RSAs, and there's a reason that you decided to exclude 644. That's the harassment RSA, and I would imagine that like someone who's maybe become troublesome for school staff who needs to be removed from the property, harassment would be a basis for. I feel like that's plausible, especially with the things going on in Nashua. And I'm wondering if there was an intent to exclude that. Thanks for taking my question, as discombobulated as it was.
if someone has been charged for a crime and they have been elected to the school board, and they would want to grab everything they could and sometimes be problematic just to make trouble for everybody. And so the idea is you're under investigation, all of a sudden we get the court and the attorneys are closing the amount of stuff you can get. And obviously you'd probably at some point be removed from the board while this is pending. So that person couldn't come back and ask for everything under the sun. Just to kind of tie up things in court by presenting this and this and this.
Representative Bolden, you recognize for a follow-up?
Sorry, I just want to take one stab at clarifying my discombobulated question. It appears that this legislation would guarantee access to a school facility by a person who's maybe been engaging in harassment against the school or students in the school, staff at the school, something along those lines. And I could see that as being plausible given the current environment in politics. And so I was wondering if that was, if you're aware of that and if it was intentional, if you feel like that's less of a risk. Thanks for letting me take another stab at it.
Well, it's very specific. You have to be elected to the school board to request these documents. And then the people that elected you are going to expect you to serve them and not your own purposes to get policy making and budgets done. So it's kind of narrow. And, you know, they would, if it was somebody that's going to harass, usually they would have been harassing before they became a candidate, and everyone would be aware of it, and they wouldn't be elected. That's usually what I've seen happen.
Thank you, Mr. Chairman, and thank you for your testimony. I'm envisioning this like if I went and requested a police report, they're going to redact certain information. So I'm assuming that the school board member is not going to want to know that little Tommy lives at 7 Bay Street and Sally lives at Mammoth Road, you know, some number. It's just the overall, how much is it costing? This is the students, these are the staff.
Right.
You know, it's kind of an overview. It's not personal information that the member would be after.
No, that's not the intent.
Thank you.
Representative Newman?
Thank you, and thank you for taking my question. As I look at the words access to any school facilities, are there any limitations, or is any elected official have access to the school to go anytime, anywhere in the school? Are there any limitations?
I don't think that's the intent, but the thing I'm responding to was this, as I say in number 3, saying, you know, this is a foolish thing, saying kids can't walk outside to go to the classroom because if somebody wanted to hurt them, they'd be a sniper. Oh, that's such a terrible statement. You can't go anywhere near school property. I mean, I don't think, I think that was overstepping the authority of that superintendent.
Follow-up?
Representative Newman, recognized for a follow-up.
Thank you, and I don't support doing, supporting or turning down legislation on anecdotal information. So I just think that there's too many things that, I'll put a question. Do you think the principal of the school will be able to control the safety of his school if any elected official has access to the school for any reason at any time to do anything?
No, I think that's understood when they go on the school board, that there's a certain limit to how they will behave, and unless they're invited into the school and asked to sit in a class or make a presentation, they're not expected to be there. But to say, we forbid you to go to any school ground, I don't know, maybe it needs a little more tweaking, but that's the intent.
Representative Sue Newman?
Yes, thank you, and thank you for taking this question. You brought up special needs and IEPs. In the work work that you have done so far, have you become aware that in some school districts, maybe a lot of them, that there are parents who don't feel their children's IEPs are being met because the school districts are, there's always a budget situation there. So have you talked about that at all? Thank you.
Yeah, that's one of the things we talked about, having the audit to determine that sort of thing, because it looks like we're spending a lot of money for very little return. So, yes, and the chairman of the Performance Audit Oversight Committee had just been on a lengthy study committee that had found so many complaints from the parents, and we're trying to find a way to fix them, and we're hoping the audit will give us some clues what we can include in legislation. Thank you for the question. It's a continuing thing.
Representative.
Thank you, Mr. Chairman. Thank you, Representative Weiler, for appearing. Can you help me understand where in line 5 regarding documents it creates an expectation that those documents are going to be redacted somehow to remove personal information?
I guess it would be easy enough for the people to present the document to say, here's the document you requested. I am required to redact this by this law. And the person would just have to accept that because the person giving you the document can't disobey a law.
Representative, if the chair may inquire with a question, if this bill were to become law and a member of the budget committee were to obtain documents from a school regarding a student's IEP, I understand it's part of an audit, but what exactly would be the goal to accomplish? What's the goal of accomplishment looking at the IEP in determining whether, are you trying to figure out what the IEP was appropriate for that student? I'm just trying to figure out what would you do with those documents?
We've spent $100,000 for this student to be counseled by such and such a person. What are the results? Is there a behavioral change? Have they learned to read? Have they learned to write? Show me the progress on this very expensive student that we've had for a number of years. I think that's a legitimate question.
Thank you, Representative. Representative Testament?
Thank you for taking my question. Are you aware that there is an identifier number assigned to each
Yes.
special ed student, and that even when Karen and I took them to court to get that data, a list of by identifier numbers and how much they had spent, we went to the Supreme Court. It is not allowed, even though that was so how are you going to get around the information?
Say that again. The Supreme Court was not allowing you to know what that identifier referred to?
The Supreme Court said, because we wanted to see if the numbers in our town were the same numbers maybe showing up somewhere else. Where's there double charging going on? And we were the Supreme Court, after a couple other courts, said you can't have that data, even though they're. It is.
Do you remember
there's a mafia here.
you remember the reason why you couldn't have it?
I have to go back and look.
Okay. I guess there's other parts of the law that needs to be changed. So we're looking forward to this audit that we're going to get back. It might take a year to get some of the information, but I think a lot of us have been stymied by the special ed costs and the secrecy that's there, that you don't even know why X student's been under special ed for 10 years and it hasn't done any good.
Just to follow up, are you aware that eventually these things are all federally enforceable? IEPs become federally enforceable. That eventually the special ed department will become head of the school.
It seems like that's the progress.
Because they'll come to the school board and say, you either pay up or go to jail.
Yeah, we had some data we looked at. 29,000 plus students are special ed coded out of 160,000. So it's getting to be a bigger percentage. I think we're one of the larger percentages in the country. for coding. So I definitely think this is an area we should all be concerned with. Thank you. Hoping I can make a 2 o'clock meeting.
Representative Rhodes.
Thank you, Mr. Chairman. Thank you for taking my question. You had mentioned HIPAA several times in your testimony, and I just want to see if you are aware that schools actually don't follow under HIPAA, they actually follow under FERPA. And under FERPA, even redacted names are still protected.
We had that question some years ago in finance when we were looking into some of the spending that was going on, and that was the word that the Department of Ed used. That's why I used it, because we knew that 20 million was being spent on some students. We asked to know, can we find out by school district or by? No, you can't find out by student. Can we find out by school district where this money is going? If somebody had a medical problem, I can't remember the classification, but some money could come not only from the school district, but from this federal Medicaid. Okay, now we have a formula for special ed. So you have to spend 3.5 times the average cost per pupil within the school district's budget before you can then ask for what we used to call catastrophic aid to come from the state. And then the state's going to pay 80% until you get to 10 times the average cost per student. And so what are you including in this 3.5 times? And you could be including money that wasn't really coming from the school district, although that's the intent. You could be including money that came from Medicaid. You could be including federal money. And you just kind of hiding it all under, this is how much got spent before we ask for things. So those are things that I get a little frustrated, why we're having to take this money out of the catastrophic aid fund, which isn't called that anymore, and because you claim you spent 3.5 times, and perhaps it wasn't all district money. So those are the frustrations that arise when you're trying to find out information.
Representative Conley.
Thank you. I don't see anything in this bill about much of anything that's been discussed during this session, but it sounds like there's a deep-seated, I wouldn't say opposition, but I guess is the goal of this to restrict access to services for students in special ed? Is that what you're really after here?
That's the side, it kind of got sidetracked. But what I'm trying to say is there are people that sit on a school board, and because they don't happen to agree with the majority and say, wait, I want a copy of that document. No, you can't have it. For what reason can't? I just said you couldn't. Or this thing like I talked about where the superintendent forbids a member of the school board from being on any school property. I don't think that's within his authority. So I'm trying to take care of those situations. We got sidetracked on special ed because of all the walls that are there, but I'll be back later when we get the audit and find out what we in fact can find out. Thank you.
Seeing no hands raised, thank you, Representative, for your testimony.
Thank you for your thorough discussion.
Good luck with the 2 o'clock.
The committee now calls Brian Hawkins from NEA NH.
Thank you, Mr. Chairman, members of the committee. For the record, Brian Hawkins, here today representing NEA New Hampshire. We represent school staff across the state, 17,000 members, and here today in opposition of House Bill 1072. And I'll focus my testimony really on the line 5, and this is relative to the school district facilities documents or school events. Specifically, our concern about one of our concerns about this bill would be the lack of definition of what a school document would be. So does that, and I think this was raised with one of the questions already, does that include personnel files, medical records, tax information, the student's grades. It's already been brought up about certain privacy laws. You know, as I read this, it does not preclude any of those things. It just says documents. And so we think that the bill is far too broad, we would ask you to find it inexpedient to legislate. And I'll conclude my testimony right there. Thank you.
Representative Wallace.
Thank you, Mr. Chairman. Thank you for taking my question.
Sure.
I see you're opposed to it, and you cited some reasons. I would expect you'd like to help us get to the bottom of this and make sure that we're getting return on our investment that we're making into the school boards. Would you provide some suggestions on how you could improve this with great specificity so that we can move forward instead of just asking for it to be killed right out of the gate?
Well, I guess from the testimony of the sponsor and the discussion that I heard, I was actually struggling to figure out what it is the sponsor was trying to do. And so we would be happy to work with the committee in any capacity that they asked but I would first want to have some greater clarity in terms of what the sponsor, I think it was Representative Pearson as the prime sponsor, is seeking to accomplish. So I see him in EDNA all the time. I'm happy to ask him that question too.
Recognize for a follow-up.
Yes, and could you speak to the apparent fact that New Hampshire has a higher percentage of students that have been identified with an IEP or in some type of a special education program? And could you speak to what your opinion might be as to the cause of that?
I will confess, Representative, I am not an expert on special education or on the IEP process. I would say that if you do have questions about that, there is an organization that deals with this, the Special Education Administrators Association. I know that they're very knowledgeable on this subject, but I wouldn't pretend to give you an answer to that question because, as I said, I'm not an expert on that.
Thank you.
Thank you for your testimony. If the chair may inquire with a question. So if an IEP for a student exceeds, $100,000, what is the issue with the member of the budget committee whose job is to hopefully balance a budget to investigate whether that money is being allocated in a responsible manner?
I'm not aware of a reason why a budget committee member cannot ask that of an administration of statistics and so forth. So, as I said, our opposition of the bill has more to do with the way it is written and the broadness with which it has been, as I said, the broadness with which it has been written. So,
and I'll follow up that question, and thank you for taking my question. Some IEPs, they can be 30, 40, 50 pages, as a 4 or 5 sentence summary, although it's a summary, it may not necessarily, I think what I understood the testimony from the representative who introduced the bill was they wanted to see if the student was making progress. Now that's not necessarily a negative reflection on the IEP, but if this district's spending over $100,000 a year, I guess what is the concern with having someone evaluate whether that's money's being used, in a responsible manner on behalf of the taxpayer? What's the opposition to that?
I don't have any opposition to a school board member or a budget committee member asking questions about the performance of their school, about the performance of the programs that they have in their school. What I'm here saying to you is that this goes well beyond that, and for you to pass this into law, I think is going well beyond maybe when we get to the bottom of this is what the actual intent of the bill is. So all I have is the bill that was issued to the public and put forward for a public hearing, and so. So I'm not sure there's much more I can tell you beyond that, Mr. Chairman.
Representative Bordenay.
Thank you, Mr. Chair. Thank you for taking my question. Since I'm not on the Education Committee, I really don't understand the workings of what is all going on as far as budget. But Representative Wilder brought up a problem with audits. Now, what are school budgets audited on an annual basis, or what is the basis for audits for school expenses?
Sure. If I would be happy to get back to you with that. I would also say I think following me is representative from the School Boards Association, who might have a little bit more insight in terms of into the budgetary and audit questions.
All right. Thank you.
Yeah.
Representative Sue Newman.
Yes, thank you. Mr. Hawkins, do you have any thoughts on what would be in these times, I'll say over the last 10 years or to currently, on what would be problematic with an elected board member just going onto or trying to go out into or onto a school property almost at any time that they think is a right thing to do, and that would be for building personnel, including teachers, if you have any thoughts on that.
I guess that goes back to some of the clarity of or lack of definition in the bill. So what would count as a school event? You know, does that mean a football game, or does that mean you know, a vaccine clinic that's happening? I don't know what the school event is as it's defined in this bill, and I don't want to bring in that issue into into this discussion. But in sitting to try and answer your question, I think that's one of our major concerns with the bill is the lack of definition.
All right, thank you.
Representative Testament.
Begin with, you're going to yell at me because it's not really a question. Schools are audited every year, but they're just on dollars and cents.
What I believe.
Hold on. Representative Testament. You basically gavelled yourself before I could. You'll have time to make open-ended statements or general whatever statements you want during the executive session. I assure you of that. And with respect to the witness, you don't need to respond to the statement.
Well, I appreciate the committee's time. Thank you.
Thank you for your testimony.
We now call Barrett Christina from the New Hampshire School Boards Association.
Thank you, Mr. Chair, and thank you, members of the committee. For the record, my name is Barrett Christina. I'm the Executive Director of the New Hampshire School Boards Association. I'm not in front of this committee often, if ever. So just by way of background, we are a private nonprofit organization. We represent approximately 161 school boards across the state, providing a variety of services, training, assistance, things of that nature, and also legislative advocacy. So we are opposed to House Bill 1072 for a number of the reasons that have already been stated and some of the questions that have already been presented from this committee. Primarily, when we're talking, I'm going to focus on the documents aspect first and unfettered access to documents within the school district. As has already been mentioned, you know, NHSBA would have significant concerns if a school board member had unfettered access to a student record. I know a lot of the conversation was about special education. I'll tell you right now, anything relative to special education is deemed confidential under both state and federal law. Department of Education Rule 1119, confidentiality requirements. There's a whole section in state rules from the Department of Education. They're already talking about the confidentiality of special education records. Further and more expansive than that, NHSBA argues that anything within a student record is absolutely not fit for anybody's consumption. A board member, teachers, administrators, special education staff on sort of a need-to-know basis, if you will, to help provide education services to that child. Certainly they would have access to records within that student file. But student records, just, as a blank statement, should be locked up. The second aspect relative to employee files. NHSBA has often advocated that if push came to shove, if a school board, which I think is another interesting aspect, this talks about a school board member. School boards operate as a collective entity. If you look at the department, the rules of New Hampshire, the statutes that deal with all the statutes impacting school districts, they're 1,500 pages long. It talks collectively, the board, the board, the board. There are a couple provisions in the right to know law that give authority to a chairperson, for example, to call a special meeting of a public body or an emergency meeting of a public body. But in the educational context, the board has to operate as a collective entity, as a single body, if you will. There's nothing in law that gives individual rights to individual school board members. I think that's important to note as well too. But so relative to the employee files. If an employee is before the school board for a hearing, whether or not that's a non-renewal, a termination, a disciplinary hearing, the pertinent documents will be presented at that hearing, the evaluations, the employee reviews, but there is other personal confidential information that may be within an employee personnel file. Perhaps they had to take disability leave. Perhaps they're on some sort of 504 plan where they need accommodations within their workplace. Other medical information, if you will, maybe in an employee's personnel file. That should be confidential as well too. Relative to the access to facilities, I guess my first question would be, for what purpose is that individual school board member coming to the school and asking to enter the school? We have some sample policies, and we would advise the school board, the school board member, if you would like to view the school, talk to the superintendent and talk to the principal and make an appointment rather than just showing up. Is it to just to observe? We can't have people just kind of coming in and out of a school building and walking in and out of classrooms where there may be confidential information going on, or observing students or things of that nature. But are they coming in to make sure that the maintenance guy fixed the boiler or put the windows in the right way? There needs to be some sort of purpose behind this. So, unfettered access to the facilities. I don't know, maybe make a phone call and talk to your superintendent or your building principal and say, I'd like to come down and see how the maintenance project is coming along. I'd like to come down and see how the new gymnasium is coming along, some things of that nature. So, relative to some of the special education concerns that were being talked about and discussed, the money is one thing, but the how and the why a student is getting services and who's providing them, that's between the parents and the school district staff, of whether or not the kid is making significant educational progress under the IEP. Could a school board or a budget committee in the aggregate get how much money are we spending on special education? Yes. Could they get numbers in the aggregate? How many paraprofessionals we have on staff that are providing special education services? Yes. But asking how much this placement costs for this particular kid and how many paraprofessionals and aides for this particular kid, in our opinion, would be touching on the confidentiality aspect that you're not allowed to breach. Last, and I'll conclude my testimony, there was some discussion, I think, among this committee and among Representative Weiler about redacting some of the particular records. I just want to let you know that there's nothing in law, the right to know law, about redacting documents. It's a judicial creation. We all live with it. We all do that as needed. A request comes in under the right to know law. It's passed off to a school district attorney. They go through, make recommendations as to what can be redacted and what should be made public. But I just want to let you know there's nothing in law that speaks to redaction of documents. It's a judicial creation that public bodies have sort of adapted to and adjusted to over the last, I want to think that was in 1989 when the court created that standard under the right to know law. So with that, we oppose the bill. We think it's way too broad. We think that school boards would be setting themselves up for liability if they gave unfettered access to some of these records. And with that, I'm happy to answer any questions the committee may have.
Thank you for your testimony. And if the chair would like to inquire with a question, and thank you for taking my question. If a member of the school board is elected by the people, why is there a concern whether a member of the school board would show up at a public school to observe how the school's operating?
So-
I mean, they have to state their reason for being there. It doesn't seem, I'm just wondering what is the concern with that?
Yeah, thank you for the question, Representative. Well, when we have students within the facility, there is private confidential information occurring or private confidential events happening within a school district. I'm not saying that, that they need to have a purpose and that purpose needs to be somehow authorized by the superintendent or the school board. But, because we have kids in the facility, we can't just let people come walking in. I understand it may be an elected official, but I guess it goes back to looking at the particular statutes and laws. An individual elected official, schools, town select boards, city councilors, they're not necessarily given any other particular rights beyond anybody else other than the right to attend a meeting and participate in the discussion and vote. For example, sir, you're an elected official, you have an employee over here. I don't think that gives you any right to perhaps look at his employee personnel file. I presume he has a boss that does that. And I know that's not in the gist with your question about looking at facilities. I will also say, too, that the last year and a half or so since we've still been in the midst of the pandemic, school districts have tried to significantly limit who's coming in and who's going out of the building just for simple safety reasons.
If I just may follow up, but I'm not sure the policy of every school. I can speak for the high school in Salem, Rockingham County District 8. I walk in, I have a name tag, I graduated from that school, I'm an elected official for that district. I still sign in, sign out, just like everyone else. You don't just, I'm not talking about just walking in like it's a,
Sure.
it's a grocery store. I'm just wondering what is the concern with having members of the school board maybe making an unannounced visit is to see really the school operating in its regular form, not to see what's going on. I just wondering what the concern is with that.
Sure.
I don't-
Thank you for the question, Mr. Chair, and thank you for clarifying. I mean, I don't think there is necessarily a problem. I mean, I think most school boards have a policy, or the building will have a protocol where you come in, you get buzzed in, you identify yourself, perhaps show an ID, get a name badge. But do they let you? And I'm asking this somewhat hypothetically, sir. I mean, do they let you just come in and walk around? I mean, I know it's not my place to be asking questions of the committee. I would find that peculiar if they let anybody just come in and start walking around a building, elected official or not, sir.
Well, I'm referring specifically to members of the school board.
Right.
Not myself. I'm not a member of the school.
Any elected official, school board member. I mean, if the board wanted to do that, or the board wanted to pass a protocol that it can do that, I think that would be fine. And if a board member wants to, like any other visitors, and looking at the sample policy we have, all persons other than staff and pupils enrolled in the school who may come to the school for any reason during the school day are considered visitors and must report and sign in at the office. No objection to that. Employees of the school system are to advise the school principal or secretary that they are in the building. A visitor must report to the school office and receive permission to be on school grounds. Maybe we could make some language to amend that there. Persons wishing to meet with a teacher for the purpose of discussing a particular problem shall do so at a time when it does not disrupt normal school program. Persons wishing to make arrangements may do so by securing an appointment with the teacher through the office of the principal or by direct contact with the teacher. No person shall visit a school without first reporting to the office of the principal as to the purpose and place of the visit. That's one sample policy we have in place.
Representative Newman.
Thank you, and thank you for taking my question. Would it be fair to say, if you would look at line 9 of the law that says, Any person denying access in violation of this section shall be guilty of a Class B misdemeanor. Would it be fair to say that that's somewhat of a reach beyond what the kind of relationship that school boards have with principals and administration peoples and offices
Thank
than
you for
it
the
is
question.
today?
Thank you for the question, Representative. Yes, NHSBA would certainly oppose that language of the bill as well too. You know, trying to criminalize something such as that, you know, we think would be an overreach.
Thank you.
Representative Welch.
Thank you, Mr. Chairman. This bill has documents in 4 sentences. If that document wasn't there, and it was just to facilitate what the problem was that created this bill in the first place, would you then be opposed to it?
Thank you for the question, Representative. Could I ask you to repeat the first part of your question? I missed that, sir.
Well, it says documents here. Now,
Yeah.
I'm familiar with the situation that created this bill.
Okay.
And the documents were not a question to me. The individual made a statement, the superintendent overreacted and barred him from the property. Now, how can he do his job when he's elected? He should have access to the facility. Would you not agree?
Thank you for the question, Representative. Yes, if a school board member wants to view the property, NHSBA has no objection to that. The situation in and of itself, I'm not familiar with that. You know, I would argue that, you know, if it was one situation, you know, one time with one school board member and one superintendent, I think somebody mentioned anecdotal evidence. Well, it may not be anecdotal, well, it may have actually happened. I don't know if we need to change the law. It sounds like an employment issue more than anything between the school board and the superintendent.
I agree. Excuse me. Follow up? I think what got me fired up about this is the fact that we're talking about all kinds of records and employee records and everything else. That's not part of the bill. I don't think that was the intent. And it just seems that we've wasted an awful lot of time talking about all these different things. And I know the documents are listed in the bill, but if they weren't, there shouldn't be a problem, should there?
Thank you for the question. Thank you for the question, Representative. Well, I mean, is the intent to mean documents or is it intended to mean public records? Because those may be 2 different things. A public record has a definition within RSA 91A, has exemptions within RSA 91A 5, I believe it is. So, you know, a document within the possession of a school district may not be a public record.
Thank you.
Representative Chesterman.
Thank you. Thank you for taking my question. I sit on a school board besides what I do here. So I'm familiar with the School Boards Association. Can you give me an idea of the size of your budget and what your what the cost is per student or per school, however you do it?
Thank you for the question, Representative. Mr. Chair, is that in any way germane to the bill? If you want to know, Representative, our operating budget is about $800,000 per year. Our dues vary anywhere between about $1,000 for a small district and about $7,200 for Manchester.
Okay.
And since you raised the issue of germane, considering that it involves members of the Budget Committee, a question regarding costs and expenses, I would find germane to the bill. If a member of the committee raised that point of order. But respect to members of the public, you're not permitted to raise such a point of order.
Thank you very much, sir.
Representative Burt.
Thank you, Mr. Chairman, and thank you for your testimony. Who do you believe can audit the records to make sure that the money's just not being, you know, that comes up disappears? And I was just curious also if Hanover and Goffstown are members.
Thank you thank you for the question, Representative. Most school boards have a professional audit done every year, and if they don't, they should. An audit is different than ascertaining whether or not you're getting a return on investment, though. I know that there are within this body, within this building, the cost of special education and the number of students we have that are identified as special education students statewide has been a significant issue for a number of years. I don't have any idea why our numbers are greater or higher in New Hampshire than they are in other parts of the country. I simply don't know that. So in terms of an audit, most school boards have an audit done every single year. Again, that's different than ascertaining the ROI. Goffstown is a member. The Hanover Dresden School District is a member as well, too, sir.
And a follow-up?
Representative Burr recognized for a follow-up.
Thank you, Mr. Chairman. Who is doing the audit then? Are they auditing themselves like police do, or is it, your association will audit them? Or, I mean, are they sided with one side? Are they in support of what they're doing, and how do you get a fair audit? Is it a fair audit?
Thank you very much for the question, Representative. There's a firm, an accounting firm here in Concord called Plodzik and Sanderson, Plodzik. My understanding is they do the vast majority of audits for school districts in the state. The professional accounting auditing firm.
All right, thank you.
Representative Conley.
Thank you, and thank you for taking the question. As the bill is written, is there any document that would not be subject to an elected school board member or elected budget committee member in any record in any district?
Thank you for the question, Representative. If I understand the question, is there any document that would not be subject to disclosure? If I could ask for a clarification.
Is there any limit on documents that could be shared with the school board member or budget committee member as contemplated under the bill?
Yeah, thank you very much. As I mentioned, if we're going to interpret documents as meaning public records, RSA 91A:5 under the right to know law lists the exemptions to public records, saying there are public records, your minutes, your invoices, contracts, so on and so forth. And then there's a very long list of documents that are exempt from public disclosure. So it's very broad based. The quick answer is it says something any record or document that whose disclosure would otherwise constitute an invasion of privacy. I'm trying to pull up the quick language right here if you give me if that'd be all right, Mr. Chair. Records pertaining without accounts. And other files whose disclosure would constitute an invasion of privacy. So that's pretty broad, and there are court cases that have to interpret that because it's so broad-based, but that's the language of the statute.
Thank you. That's not the language of the bill, but and under the bill, as the bill is written, is there any part of the school that a school board member could not access? The locker rooms,
facility,
cheerleading practice, vaccine clinic, anything at all within a school building that this person could not access as the bill is written?
Thank you for the question, Representative. I don't believe there would be any limitations.
Thank you.
Representative Rhodes.
Thank you, Madam Chairman. Thank you for taking my question. Would you, what did I say? Oh my God. My apologies, Mr. Chairman. You're so forgiving. I juggle two committees, guys. Thank you for taking my question. Would you agree that one way to solve the problem of documents would be, as an example, we've talked a lot about IEPs. So if in a student's IEP it says 2 hours of counseling a week, and it's an outside counseling agency, and you are billed for those services, if you're the treasurer and you're signing off on the checks and the check is going to ABC Counseling, that you are able to have a copy of the invoice. You can absolutely cross off the student's name, but you can see the service provider's name, the amount of hours, and then it is the job of the personnel to match up that invoice with the IEP services on the services page.
Thank you very much for the question, Representative. I think I understand what you're getting at, and NHSBA generally takes the position that anything dealing with money is going to be public information or public record anyway. Whether or not it's an invoice or a bill, certain things will be redacted. The student's name, Johnny Jones for the 2 hours of physical therapy, that's going to be redacted. But the invoice and the check that the school district writes to pay for that service is going to be public information anyway. Anything dealing with money, our default position is if it deals with money, it's going to be public information.
If the chair may inquire with a question, and thank you for taking my question, and I'll preface this by saying I'm not suggesting that a member of the budget committee is in a position to be evaluating whether an IEP is appropriate for a particular student or not. They weren't involved in that process. What I'm concerned with is if a certain number is given to the budget committee or to the school board, if they don't have access to that, the information in the IP, how are they supposed to make an informed decision whether to approve that figure or not? It seems that, my point is, it seems like they're operating in the dark, and I have no reason to think those numbers are being misrepresented throughout the state. It's just, if one were to inquire about that number, they don't really have much information to go off of other than the number.
Thank you for the question, Mr. Chair. I mean, the IEPs are a couple different. I'm trying to think of the right angle to go with my answer here. First of all, special education is so highly regulated by the federal government that the state laws, the state rules are a little bit broader, if you will, giving more rights to students in New Hampshire than the federal law. But in terms of whether or not you're going to pay for it, school boards have one option relative to special education costs: pay for it. It's as simple as that. Federal law dictates that these services be provided. The only school board responsibility relative to special education is to fund it and put it in the budget and then pay for it. And I'm not trying to be blunt or flippant, but that's the reality of what special education is about. You pay for the bill. Now, can a school board inquire, do not a financial audit as we were talked about, but an audit of staffing in conjunction with the superintendent? Do we have the right staff? Do we have the proper number of staff? Are they being allocated the right way? Is there a way to cut this staff and add this so perhaps we get better services and drive down some of those costs? Absolutely. That's a conversation that the school board should have with its administrators if it feels that's prudent relative to student concerns or budgetary concerns. But they're not going to get that from looking at the IEP. It's not a school board's responsibility to ensure that Johnny got his 2 hours of speech therapy. There's no school board hearing relative to special education. It's all run through the Department of Education. There's a complaint process through the Department of Education. The school board's responsibility for special education is to staff it and fund it. And that's the law. I'm not saying that because that's my opinion by any means.
Thank you. And if I can just ask a follow-up to clarify your testimony, are you suggesting that the school board is not shouldn't be in a position to really question the figure presented to itself? It's just whether to approve it or not?
Thank you for the question, Mr. Chair. No, the board can certainly have those questions during budget time, but if a child is found to be in need of services under special education law, and the IEP team through the IEP process requires this level of services, this number of aides, this number of out-of-district placements or services or whatever it may be, the IEP team, parent, teacher, special ed teacher, maybe a special ed director, maybe a physical therapist or a speech therapist, that team, 6, 8, 10 people are meeting and they determine what the services are that the child needs. And then once that is ascertained, when they determine what the services are that child needs, the district has an obligation to pay for it, presuming that the parents in the district agree to those being the services that are needed. The school board does not get involved in determining whether or not Johnny needs 1 hour of physical therapy or 2 hours of physical therapy. It's a student matter that's dealt with at the building level with teachers and specialists and the parents being active participants in this.
Thank you.
Thank you.
Seeing no hands raised, I want to thank the witness for his testimony.
Thank you very much.
Witness is excused. If there's any members of the public who wish to testify, you haven't already. Seeing none, we will now close the public hearing on HB 1072. I just remind the members, we'll be in recess for till 2:55. All right, we're gonna open some executive sessions. Just
Well, we can do two. I have two more sheets.
well, first I'm gonna open the executive session on HB 1400.
Actually, this isn't even,
Wait, which one?
this is something different. What is that? That's assignment.
Oh, you want? Excuse me. Sorry. We're opening the executive session on CA-CR 35. My mistake. Thank you, Representative Burt. Yeah, we'll go with 1400 next, but we'll start with CA-CR 35. We've now opened the executive session on CA-CR 35.
I thought it was two. One was the attendance. CACR 35.
Representative Testament. Representative Testament, do you wish to be recognized to make a motion? And is there a second? It has been seconded by Representative Welch. Representative Testament, do you wish to speak to your motion of inexpedient to legislate?
Like all the other two, unnecessary constitutional amendment. I agree with with Representative Muse that this doesn't rise to a constitutional amendment, and it's we don't have other ones about agriculture, so we don't need this one.
This is another cannabis bill.
Yes. Thank you, Representative Testament. In respect to now we had a few CRs involving cannabis. This one, I think, is the most detailed, at least in the sense of if it were to become a constitutional amendment, it's clear what it would do. However, this is something that can be done through an act of legislation. It wouldn't need to be done through a CACR. The only difference is whether we think one would become law over the other. Obviously, there's a different procedure process, but I mean, all adults have the right to possess, use, cultivate cannabis subject to regulations or taxes on commercial activity as the general court may impose. So, I mean, to me, that can simply be a legislative, that can be an RSA as a policy, not necessarily a constitutional amendment. That's just my only observation of it. The policy issue aside. Representative Spetia.
Thank you, Mr. Chair. Yeah, no, I think I'd be happy to, legalize cannabis, and I think that all the arguments that we've heard, that we've already had on this, I think we can just put it as, we can move forward and just take a quick vote on this. But on my end, I would probably going to support, but I know how the end's going to be.
I'll just throw this out there. If things don't go the way I hope with another bill, if someone were to refile a CACR next term, this is the one I like the best out of all three. That's just my opinion, but that doesn't matter. Representative Burt.
Thank you, Mr. Chairman. After having my friend in front of me turn around and ask me why, I thought about it, why I voted to ITL the other bill. And he's correct that the first CACR was ITL'd, and the second one's ITL'd. And then my good friend, Representative True, keeps looking at me. And I think I'm going to oppose the ITL this time because, we should let the voters at least have one of the bills. And as you point out, that this is the best of the group of them. So I guess I'm gonna probably go with my two colleagues that I mentioned.
Representative Marston. Representative True.
Thank you, Mr. Chair. So it's been said that we don't need to have a constitutional amendment. We could just pass a law for this. But we haven't. And I don't think we're going to pass one this year either. So this is the opportunity to let those anecdotal voters who say that they are in favor of legalization to have their voice, because they're not getting a voice through the representatives this year, because legalization is not going through the House. It's not going through the Senate, and it's not getting past the governor, for whatever reason. The important thing is, we're here as representatives of the people. Surveys say the people would like it to be legalized, and this is the bill that can do it. So I will not support the ITL. Thank you, Mr. Chair.
Seeing no hands raised, at this time we'll now move the question. If you're in support of the motion of inexpedient to legislate, please say yea. If you are opposed, please say nay. The clerk will now call the roll.
Vice Chairman Roy.
Yes.
Representative Welch.
Yes.
Representative Burt.
No.
Representative Rhodes.
Yes.
Representative Green.
Yes.
Clerk votes no. Representative Testerman.
Yeah.
Representative True.
Nay.
Representative Pratt.
Yes.
Representative Marston.
Yes.
Representative Harriet Gathright. Representative Sue Newman.
Yes.
Representative Jack.
Yes.
Representative Bourdonnais.
Yes.
Representative Muse.
Yes.
Representative Ray Newman.
Yes.
Representative Bolden.
No.
Representative Conley.
No.
Representative Bradley. Representative Espitia.
No.
Chairman Abbas.
The chair votes yes.
14 yeas, 6 nays, 1 not voting.
Motion of inexpedient to legislate passes. Representative Testman, will you be submitting it? I envision that. Different vote tallies, but yes. Will they be a minority report that also will be very similar?
Yes, I'll write a minority report.
Thank you, Representative Burt. At this time, we'll now close the executive session on CACR 35.
We've got mail.
Yeah, I don't know if it was forwarded to you. Give me a chunk of
1,400.
Is that what's next?
We can do that. We can do 1,400 or so we're passing around amendments to, one is an amendment for HB 1400, which we're going to do next. We're also, just for the sake of expediting the process, we're passing out an amendment for HB 1333. So Don't be surprised if that one comes up next.
That's a different one.
What? It's a lot. At this time, we will now open the executive session on House Bill 1400. At this time, the chair recognizes Representative Roy.
I'm going to make a motion of inexpedient to legislate on HB 1400.
That has been seconded by Representative Marston. Representative Roy, you wish to speak to your motion of inexpedient to legislate?
I do. While I'm sure all of us, including myself, are getting a little tired of talking about marijuana, this proposed statute is looking for a problem that's already been solved. The Supreme Court has ruled that it's not probable cause. The scent of marijuana is not probable cause. Possession of marijuana is not a crime, so the scent of marijuana can't be probable cause for a search because it's not evidence of a crime. So I don't see the need to codify this and clutter up our criminal statutes with a bill that's already law. It's redundant based on decisions of the court. So it would be putting something in statute just for the sake of putting something in statute, in my opinion. And that's why I would support an ITL of this.
Representative Bolden?
As was discussed in the public hearing on this bill, a Supreme Court decision is not the same thing as law. Each individual police department has to be aware of the decision in order to follow it. And just as a point of clarification, I believe Representative Roy said that possession of marijuana is not a crime. It is in some cases, depending on the quantity. And that is the issue at hand, is that an odor may or may not be evidence of a crime, and that's the problem that's created in using an odor as probable cause. If there were something that would make a person easily, or a vehicle or a space easily smell like alcohol, and let's say it involves a vehicle that's being driven, there would be an issue of, do we smell alcohol because someone's drunk, or do we smell alcohol for a different reason? And it is the case that a lot of natural things like skunks and different types of perfumes can smell like marijuana. I included as a handout the Supreme Court decision that's being referenced. It is necessary for the legislature to codify things like this if we agree with them, or to codify in the opposite if we feel that the Supreme Court arrived at a conclusion that we don't support. We don't just let the Supreme Court make law. We have the right to undermine their choices if we like, as the legislature. So let's say we didn't agree with this decision, that would require legislation. So if we agree with it, it also requires legislation. We've written and passed laws in this body that were deemed unconstitutional, and they needed to be repealed by this body after the fact. So it's an opinion, but it's just an opinion, and we do need the law. It's not clutter. It's the Supreme Court decision that really is clutter, because in the sense that clutter is confusing and messy, if there's police departments or individual officers who aren't aware of this decision, then we're going to have different outcomes that depend entirely upon the knowledge of the persons involved and not on what the law is. And I just want to mention, as is obvious to everyone, there's an amendment that deals with the concerns about the language that were brought up in the hearing.
Representative, you may state your point of order.
We are discussing the bill, not the amendment. Thank you.
In respect to the point of order, the question that's before the committee is not the amendment. It is an
I
expedient.
wasn't discussing the amendment. I was saying
well,
that it exists.
Let me, if I could just finish. So try to.
I have every right to say that it exists. I do
I-
have every right to say that it exists, Daryl.
No, the member will suspend.
I understand how the rules
The member
work,
will suspend.
and it's so inappropriate
And you
for
are
you
out
to
of,
cut
you're,
people
you're
off.
out of order. for
This is
continu-
supposed to be a deliberative
you are out
body
of
where
order
we have
by con-
rational
If you're, let me just, I have to rule on the point of order. Now, I understand you don't want to wait for that ruling, and perhaps that ruling may be even favorable to what you're saying, but you won't actually let the chair finish and make a said ruling.
You're not a judge. You don't rule on points of order.
Yeah,
You're a legislator.
Yes.
Listen,
So
there's
you're
I've
out
never
of-
heard
you're
of
out of
ruling on
order.
a point of order.
The member's out of order again. I'm going to ask you to suspend your time to speak.
But just so you know,
All
you
right.
don't rule on anything because you're not a judge. I just want to pass that
Would you
along.
like to challenge the ruling of the chair? You're free to make.
No, I'm just letting you know that your language
member,
isn't.
The member
doesn't
will
make sense.
suspend.
You asked me a question.
and
I'm
you
answering
are free
it.
to challenge the ruling of the chair if you would allow the chair to make said ruling, which you may or may not even agree with. So
If you want to talk, stop asking me questions.
So I'm going to rule the member out of order because you're continuing to speak without being recognized to speak. And I'm asking that any testimony, or excuse me, any comments be limited to the underlying bill because the question before the committee is inexpedient to legislate. So I'm going to allow you to continue to speak, but please try to limit your comments to the underlying bill, not the amendment.
All I had to say
You don't need
at
to
the end of my
you don't need to
testimony,
justify it,
not
you may
testimony, but
continue.
my comments on the bill was,
Thank you.
there's an amendment. That was the end of my sentence. But instead, we've had this protracted routine because there's some kind of gotcha attitude in this committee that doesn't need to exist. That was literally all I had to say.
The member will suspend. Please don't, you're not permitted to assign motives to other members.
I'm not
So
assigning
you're out of-
motive
you're
to
out of
members
order.
based on legislation.
I'm ruling you out of order and you're not recognized to speak. If you continue to speak, you're not speaking while recognized. So you're just speaking out of order, disrupting the committee. Do any other members wish to speak? Representative Roy.
Thank you, Mr. Chairman. Back to the matter at hand. With regard to Supreme Court decisions being law, they actually are. Unfortunately, I agree that But we have a long history, Arizona versus the Miranda, Terry v. Ohio. All these things are not codified, yet they are followed by the police. Miranda warnings are required when someone's in custodial interrogation. We've heard testimony about that numerous times in this committee. So the police departments will be well aware of the court decision. I don't think there are any police departments in the state of New Hampshire that are not aware of a decision from 2 years ago that said they cannot search cars based on the smell of marijuana anymore. So again, I go back to I don't feel that this is necessary based on the fact that it's already the law of the land vis-a-vis the decision of the Supreme Court of the state of New Hampshire. Thank you.
Representative Testman?
I talked with some police, and their only point was you can't use marijuana, and I think that's what this one said, as the only reason for getting a search warrant. It has to be used as a contributing factor, or whatever you want to call it. You know, something else you see in the car or something. So, and that's the only thing, that my problem with this bill is that it makes it an only reason, and that isn't, you know, what we ought to be doing.
At this time, we'll now move the question. If you're in support of the motion of the inexpedient to legislate, please say yea. If you're opposed, please say nay. The clerk will now call the roll.
Vice Chairman Roy.
Yes.
Representative Welch.
Yes.
Representative Burt.
Yes.
Representative Rhodes.
Yes.
Representative Green.
Yes.
Clerk votes yes. Representative Testament. Yes. Representative True.
Yay.
Representative Pratt.
Yes.
Representative Marston.
Yes.
Representative Harriet Gathright.
No.
Representative Sue Newman.
No.
Representative Jack.
Yes.
Representative Bourdonnais.
No.
Representative Muse.
No.
Representative Ray Newman.
No.
Representative Bolden.
No.
Representative Conley.
No.
Representative Bradley. Representative Espitia.
No.
Chairman Abbas.
Chair votes yes.
12 yeas, 8 nays, 1 not voting.
The motion passes by, is it 12? 12 yeas, 8 nays, the motion passes. Will there be a majority report? Will there be a
Amanda said she would do the minority.
At this time, we will now close the executive session on HB 1400. At this time, we'll now open the executive session on House Bill 1333 as relative to previous convictions for driving while intoxicated. This time, the chair recognizes Representative Welch to make a motion of.
Thank you, Mr. Chairman. I move that we amend House Bill 1333 FN with Amendment 0813H.
So just to clarify, Representative Welch, you're making a motion of ought to pass, and you wish to offer an amendment. And is there a second to that? Seconded by Representative Bourdonnais. And Representative Welch, if I'm speaking correctly, there was a drafting error in the bill, and the amendment's correcting that drafting error. Is that?
That is correct. It's the same error that we had once before.
Thanks for pointing that out. At this time, we'll now move the question. If you are in support of adopting Amendment 2022-0813H, please say yea. If you're opposed, please say nay. The clerk will now call the roll.
Vice Chairman Roy,
Yes. Yes.
Representative Welch,
Yes.
Representative Burt,
Yes.
Representative Rhodes,
Yes.
Representative Green,
Yes.
Clerk votes yes. Representative Testament, Representative True,
Yay.
Representative Pratt,
Yes.
Representative Marston,
Yes?
Representative Harriet Gathright,
No.
Representative Sue Newman,
Yes.
Representative Jack,
Yes.
Representative Bourdonnais,
Yes.
Representative Muse,
Yes.
Representative Ray Newman,
Yes.
Representative Bolden, Representative Conley,
Yes.
Representative Bradley, Representative Espitia,
Yes.
Chairman Abbas.
The chair votes yes.
18 yeas, 1 nay, 2 not voting.
The motion passes. The amendment's adopted. Representative Welch, you wish to be recognized for a motion of ought to pass as amended?
I make that motion, yes.
Is there a second? That has been seconded by Representative Marston.
You know what? Can I change my, I'm sorry, this was the amendment. I meant yes. I apologize.
I don't,
That's a
can't
motion
change
for
it.
reconsideration,
I have
but
to.
we could just adj-
Wait a minute,
the
do-
proper
we would
way.
Do I have to go through all that?
we would
Have to do a
technically have to,
motion.
Never mind then. Forget it. Leave it.
I will say it would not change the outcome, and
Doesn't matter.
it's,
It's like the vote right.
it's,
Never mind. Forget it. I'm fine.
You're a brave soul.
Representative Harriet Gathright, you could make it up by voting in favor of the ought to pass as amended.
I mean, it was a unanimous vote, right?
Just throwing it out there. Representative Welch, you wish to speak to your motion?
No.
Well, I think I,
Okay,
Oh
then.
my
well,
goodness.
I will say I summed up the intent of the bill with my testimony. Again, it's, just to clarify, it's only applying to third and fourth offenses. And the idea is, in order to convict someone of a subsequent offense, they have to actually be convicted of the first offense. So if someone were to get arrested 3 times for drunk driving in a 2-month time period, you're unlikely to have a conviction on those. So they're going to be charged with several first offenses. So I think extending it for the look-back period for third and fourth offenses to 20 years, you're really focusing on habitual offenders at this point. So I think it's a modest way to address what I would say repeat offenses that put public safety in danger. So I hope you all join me in supporting ought to pass. And it did pass this committee last term. Seeing no hands raised, we'll now move the question. If you're in support of the motion of ought to pass as amended, please say yea. If you're opposed, please say nay. The clerk will now call the roll.
Vice Chairman Roy,
Yes.
Representative Welch,
Yes.
Representative Burt,
Yes.
Representative Rhodes,
Yes.
Representative Green,
Yes.
Clerk votes yes. Representative Testerman, Representative True,
Yay.
Representative Pratt,
Yes.
Representative Marston,
Yes?
Representative Harriet Gathright,
Yes.
Representative Sue Newman,
Yes.
Representative Jack,
Yes.
Representative Bourdonnais,
Yes.
Representative Muse,
Yes.
Representative Ray Newman,
Yes.
Representative Bolden, Representative Conley,
Yes.
Representative Bradley, Representative Espitia,
Yes.
Chairman Abbas.
The chair votes yes.
19 to 0. Move for consent?
So moved.
No objections. Consent, good.
Representative Welch, I will do the honors of the majority report. I wrote one last year for the. It's there. It's published. I'll have to track it down, but I'm sure I can repurpose that. At this time, we'll now close the executive session on House Bill 13 33.
So who did the auto pass as amended? Was that the same Welch and Bourdonnais? Wallace? Okay. Thank you.
At this time, we'll now open the executive session on HB 1085. That's relative to ignition lock requirements. Sure. You can recycle after you transport it. At this time, the chair will recognize Representative Roy to make a motion.
I would like to move HB 1085 as ought to pass.
Is there a second? Re- re-
get that. Could you try again?
Rule that out of order.
So, I apologize. Representative Muse, you are recognized. Sorry, you seconded the motion about to pass. Representative Roy, do you wish to speak to the motion?
I would defer to the chair to explain to the committee his thoughts on that.
Representative Muse, since you seconded, would you wish to address it? You may reserve for later on the discussion if you'd like.
I do think that we heard testimony that, that this particular bill does address a significant loophole in our law now. I think the last thing that any of us want is to provide loopholes for drunk drivers to get back on the road. So this bill would go a long way towards closing that loophole, and suggest we pass it.
And Representative Muse, the term loophole is what came to my mind as well. When I saw this, and I heard a lot of discussion about, you know, any vehicles registered to that person, and whether that's the economic side of that. I certainly appreciate that, but the goal of the interlocking device is to prevent the person from operating a motor vehicle without blowing into the machine at all costs. If the person were to violate this law, that in and of itself, the system has already failed, even if that person wasn't even intoxicated or impaired. So I don't think it's unreasonable to make a presumption that if a vehicle is registered in that person's name, that they tend to drive that vehicle. And then having to demonstrate on a regular basis, I'm not sure if there's courts have interpreted that, but if they're operating a motor vehicle and they have not blown into the ignition interlock device, they're basically walking around the system and taking advantage of and exploiting it when they've either have been arrested and convicted several times, or been involved in an aggravated offense. So I think this really captures the intent of what the law should have been from the start. So I would support not to pass. Representative Bourdonnais.
Thank you, Chair. I'm going to oppose the auto pass. I really don't like this bill because it requires all vehicles that basically are registered by the individual to have interlock device on them. Not only does that punish the person, but also punishes anybody that's driving those vehicles within the family. I think that the original language takes care of what we wanted to do. We would really prefer that while this person is under this order, that anytime he drives, or she, they have to drive a vehicle with an interlock device. And that is not clearly stated in this. This means that any vehicle he uses or has registered to his name has to have an interlock device. And now, we are not necessarily agreed that the vehicles in this case are just exclusively automobiles. It could be also, as mentioned earlier, motorcycles, snowmobiles, and possibly even boats. And we did learn from the lobbyists that such devices are available for all those vehicles. So it's unclear if they really want to limit this to automotive or vehicles for the road, that was not stated. So this is, we're talking about $1,000 a year for each vehicle. So I'm going to remain opposed. Thank you.
And I just would say, Representative Bordenay, the existing law is that any vehicle registered to that person already would require the interlocking device. So that's the existing law. What this is changing is it's or used by that person on a regular basis. So it's just striking the regular basis, so strictly they're using a vehicle. And the point of that interlocking device, if they're using a vehicle, is to, well, have to use the interlocking device. So it should apply to any vehicle.
So, when I redirect you?
Yes.
But striking those three words means that vehicles that the perpetrator has in his household but never uses has to be interlocked. So it does put a different emphasis. Instead of being vehicles that the person uses on a regular basis, which would probably want to mean any vehicle they're likely to use should have an interlock device, means all vehicles in that household have to have an interlock device. That means if their spouse is going to be driving a vehicle, they are also subject to the inconvenience of an interlock device while they are operating that vehicle.
Unless they register it to themselves.
My interpretation is that if the vehicle is not registered in that person's name, it's registered in the spouse's name or partner's name or whatever, then in that scenario, it wouldn't require an interlocking device. Now, if they were to use their spouse's car, that's different. That would be problematic, and it's up to that's a decision they would be making on whether they want to put one in both vehicles or just one of them. You may respond.
I don't know about your household, but in my household, all our vehicles are registered by both myself and my spouse. So I think that's the case for most households.
Well, I understand the concern you're raising. I will just say that is a problem under the existing law.
I disagree. It's not in the existing law.
It is. It is.
But
Can I?
We're going to go on this one. Representative Wallace and.
Okay.
Thank you for recognizing, Mr. Chairman. Just to carry on with your discussion, as somebody who has many years' experience installing and calibrating these devices, this bill is designed to address a loophole. I've had many clients that would drive their motorcycle, because from a liability perspective, I would never install a breathalyzer interlock because it does require an additional blow randomly and frequently as you're driving on the road, and that's not very safety-minded on a motorcycle. Another item addressed in this bill is the DMV will mark the driver's license in some manner for these people, so that if they go to rent a motor vehicle, you're going to have to produce your driver's license. They may not have access to your driving record, but with that mark of the beast on your license, they're not going to rent you an automobile because it doesn't have that interlock device, thereby preventing that workaround of the system that we've got in place to prevent these individuals from operating on the road while they're impaired. Just another couple of thoughts.
Representative Harry Gathright.
Thank you. So can I just ask him a question on what he just said? So you're saying that these people have something on their license?
No, there's a provision in the bill that the DMV will mark their driver's license and put a decal on their registration plate, so it's blatantly obvious to the motoring public and to people that may look at their driver's license that they have a requirement for this interlock device. So, if they're exhibiting lane control issues, maybe they're trying to operate this the interlock while they're driving down the road, and maybe some would drop a dime if they're having problems.
Okay, so I too thought this was a good bill, but I'm going to say last year, whenever we had this before, I probably never read it through. But today, in reading through it, that part of the bill that states, that any and every car that you own would have to be, you would have to have that device on it. I thought this was a good way to clean that up, and that was my recommendation to the representative. However, after she left, she did send us an email, a few of us an email, and she chose not to put in, to clean up the bill so that it would be palatable to the entire team. So with that said, I don't think I can vote in favor of this bill, because I don't really believe that anyone, I don't care how many vehicles you have, and what they said was that the motorcycle, anything that's drivable, is supposed to have a lock. That's what one of these people said. Okay, so let's say you have 10 vehicles or whatever in some, or motor vehicle, whatever you want to call them, anything that you can drive, you would have to pay $150 or whatever the cost is for every last one of those vehicles. I'm sorry. I just think that's unreasonable.
Yes, and maybe Representative Wallace, maybe it's wrong, but I think this went to Transportation Committee last year, not to us.
Oh, okay.
Yeah.
I thought it came to us, and I must have didn't read it all or something. But I took this as, even though I like what they wanted to do with the bill, I still felt it was an opportunity to clean up the bill, and I feel that was rejected.
Well, just from the technical aspects of it, if you're a multiple vehicle owner, there are multiple units that are installed into the vehicles, but there's only one breathalyzer. Okay, they might have a spare, but that handset is the breathalyzer unit itself, and it communicates with the interlock in the car. So where they can only operate one vehicle at a time, or maybe there's a spouse, they may have an additional handset. So it's not a complete $1,500 install in each vehicle. Okay, they might have that interlock, the component that disables the start circuit. Okay, and then you don't leave the breathalyzer in the vehicle because it's temperature sensitive. You keep that in your home with you, and you bring it out in the morning and plug it into the car. You blow through it, you get a clean sample, it allows you to start the vehicle. So it's...
One more question then. You said it was 1,500?
I was operating in Massachusetts.
It was 15. Okay, but didn't that guy say it was 150?
It depends.
Did I miss something?
There's a.
But even with that, that's even worse.
Well, just like financing an automobile, you can do it different ways. You can lease it,
Yeah.
you can buy it outright, or you can buy it. You can put some money down.
Oh, okay.
We did it all a myriad of ways. Most people just paid a monthly lease rate, but there was an advantage for paying it off up front. So.
Representative Newman. Ray Newman.
I agree. I agree with Representative Bordenay, especially when he brought up the point about vehicles that are registered to both spouses. And if you read just the wording of the bill, if I can find it here, that they shall be required by the court after a period as defined in RSA 259-43 in any vehicle registered to that person or used by that person, and then they removed what used to be the out that would confine it to, wouldn't require it to go on more than one vehicle, and it goes on from there. And so I think that what you have, just because the wording is the way the wording is that if you take out the exception, and that's what we want to do, then for vehicles that are registered to two different people, and if that's all the vehicles in the house, this would require that you install one in each one that is registered to that person, because we've removed the exception. So I think that's the first point. And the second point is, even if it's not now I'm confused about whether it's a breathalyzer or whether it's a unit in the car, you would have to you would have to install, in my reading of the words, at least whatever component is a breathalyzer, whatever that means, or whatever interlocking device, whatever that is, you would have to install it in 3 cars where you had 2 spouses registered to the vehicle.
Representative Sunderman.
Yeah, Representative Gathright and the other Representative Newman covered most of my thoughts, but I'm stuck on line 23 where it says in any vehicle registered to that person or used by that person. So is this it doesn't say either or, so I didn't know if that was some way that if somebody had 2 cars registered or 3, whatever, they could say, no, this is the car I use on a regular basis, so I only need to install the complete gizmo on this one, but not those.
So this is my interpretation, and this is the existing law. Take this bill, even if we don't pass it. Any vehicle that is registered to the individual's name, if they're required to get the interlocking device in their vehicle, any vehicle registered to them, period, whether it's their name and their spouse's name, would require the interlocking device to be installed in the vehicle. It also would be required to be installed in vehicles not registered in their name that they operate on a regular basis. The issue is, operate on a regular basis, what does that mean? How frequent would one have to use a vehicle for it to then be considered on a regular basis? And what I understood the testimony to be from the representative who sponsored the bill and introduced it was that on the regular basis, the intent is anytime this individual is operating any vehicle, whether it's registered in their name or not, is to take the breath test and to use the interlocking device. So existing law, that's already the case. What this is just doing is clarifying that you don't have to establish on a regular basis. So if I'm required by the court to use the interlocking device and you lend me your vehicle, although it's a nice gesture, if the interlocking device is not installed in there, I would not be permitted to operate it. If this were to pass, if I only use it one time, you wouldn't need to do it under the current law. But the problem with that is I'm getting around the requirement that the court made that I use that interlocking device.
And just to clarify what Representative Wallace just said, I don't think I heard this morning, maybe I don't remember, but this is the first time I'm hearing that if you've got 3 cars, you could get 3 sets of things, but only one would be the full one that you would be expected to use, or do you move it from one to another?
Yes, the systems, I don't know if you remember back, 20 years ago when we actually installed security systems in the cars when they didn't come factory equipped, you'd have something that would prevent the car from being started. That's the only part that remains in the car. The little handset, regardless of the manufacturer, is on a little coiled cord, and that remains with the individual because that's what's very expensive and has a proprietary technology in it and is required to be calibrated on a monthly basis. That goes into the office with the people, it goes in their home, so they could just move that from car to car. and that contains all the data, that what we call the handset. Okay, but you could only operate one vehicle at a time, so if you've got multiple drivers, you would probably in reality need at least 2 complete systems, so that in the event that one vehicle's out of the driveway, you still got a handset to run that other vehicle. Because unless you're trained, you're not gonna be able to get it started.
Thank you.
Representative Jack?
Thank you, Mr. Chairman. The chairman did a great job of pointing out that line 5 is verbatim in existing law, and it says, because of the word "or" at the end, that any vehicle registered to that person has to have the interlock device. That's existing law, so voting against this bill to
basis,
circumvent that isn't going to solve your problem. There does seem to be, there has been a lot of sense in the committee today that that requirement isn't a good idea, but this bill is, unamended, this bill is not, voting against this bill is not solving your issue. Let me suggest a couple of ways you could proceed. You could hold the bill and do an amendment. The Department of Safety was a little leery about agreeing to that amendment in real time. So if you were to hold the bill, if you had another executive session, you could hold the bill and amend it. It does seem that the committee is very interested in deleting that requirement. You could file a bill next year to delete the requirement. You could try to get the Senate to amend it. But voting against this bill today, as it sits, does not help with the concern that a lot of the committee has about that language, about any vehicle registered to.
Representative Spitia?
Yeah, I agree with the statement of Representative Jack. I think, you know, while sure there are some issues with the existing law, I don't think this bill is meant to address those issues. This bill is meant to address the loophole that is currently, that is something that, I think a lot of us can try to get behind. So I think, I want to support this bill move forward.
Representative True?
Thank you, Mr. Chair. Well, most of it's already been said, but I'll say it again because I like hanging out here. I hear the argument that any vehicle registered to that person is already part of the law. Well, so is on a regular basis already part of the law. In three places on this bill, the law as it's now written says that you must spend all this money on any vehicle registered to that person. That seems very too strong a punishment financially for somebody who's done wrong. And that can be easily corrected if we stall long enough to another day, so that an amendment dropping that any vehicle registered to that person and dropping the on a regular basis will certainly get my support, because forcing somebody to register 4 cars because they're registered under his to do the interlock on 4 cars because they happen to be registered under his name is not going to stop him from borrowing Daryl's car tomorrow. It's not going to stop him from borrowing anyone's car that doesn't have the interlock. That's on the person. The person knows they messed up, and they have to follow the court orders. But forcing somebody to put this interlock on any vehicle registered to that person, when that doesn't serve any purpose at all, is why I can't support the OTP, and I would hope that it doesn't go through today, so that perhaps removing any vehicle registered to that person and removing on a regular basis will do exactly what this bill, as presented, meant to do. Thank you, Mr. Chair.
Representative Marston?
I
Thank you, Mr. Chairman. I will not be long-winded. I will be voting to ITL and not approve the motion that ought to pass. I will be voting against.
Representative Burt.
Thank you, Mr. Chairman. I think if Scott could answer, I'm assuming it would be him to answer this question, because I just want to understand, is it current law right now, or is it proposed law? I have a 53 Farmall Super C tractor, a car, and a truck that I drive. Then my wife has a car that I will drive once a week when I go fill it up with gas. And occasionally other times, but most of the time I drive the other cars, you know, so would I have to install them in all 4 vehicles? And if the answer is yes, let's say if I was the DWI person, which I don't drink, but if I did, and would I have to, you know, would it be installed in all 4 vehicles? And how would my wife be able to drive her car to work if there's one of those devices in her car, because I do occasionally drive it? So I'm just curious how this works. Thank you.
Okay, there wouldn't be a need to put it on your tractor unless it's registered and driven on the road.
It is.
Okay, well, that's interesting. It certainly is technically possible. As far as operating the vehicle with the interlock, she would have to operate that, and it's quite a task. If you've ever had a pulmonary function test or deep breathing exercises, this is not something you just kind of breathe into. You've got to breathe from your bottom of your soul and hold it, and you know, it's not the easiest thing to do. So, but that's how she would have to operate it.
Wow. Okay.
Yep. No half breaths, it'll fail.
Is that current law? Or is that proposed law?
Well, what would happen is, could you get around that device? Yes, you could, but it would also set a demerit into your unit. It would be you would be locked out. It would detect that it had been bypassed, and that would be a violation on your part, and it would go on your record. You'd have to answer to it with the DMV.
And Representative Burt, under the current law, if you were to be a great husband and take your wife's vehicle to get fill up the tank, top it off once a week, I would consider that to be operating the vehicle on a regular basis. Now, that's not even considering the random times you may just randomly drive it, but so under the current law, you would have to register or have the interlocking device installed into all the vehicles. I will say the easiest way for an individual to avoid this hardship is to not commit multiple drunk driving offenses, be double the legal limit and get arrested for drunk driving, or be involved in an accident while impaired from drinking alcohol. So although I do sympathize with I guess some of the restraints this may put on an individual, this is a very easy situation to avoid, in my opinion. So just throwing it out there. Representative Welch.
Thank you, Mr. Chairman. I really can't believe we're having this discussion over somebody who drives a car drunk. Does anybody here know anyone who has lost a family member or a friend from a drunk driver? I don't care what kind of a cost we put on a drunk driver. I don't want him on the road.
Yep.
End of story.
And thank you for that moment of clarity, Representative Welch.
Representative Roy.
Thank you, Mr. Chairman. I've heard a lot of talk about, the person's going to have to do this and we have to do that. And let's get back to piggybacking off what the chair said. Driving's a privilege. It's not a right. You don't have a right to drive. You have a privilege to drive. No one's forcing you to install anything. You just don't drive. If you want to drive, after having been convicted multiple times or having been convicted double the legal limit, you say, you know what, I'm going to go ahead and enter this agreement with you, State of New Hampshire, so that you let me drive. Then you are going to have to live up to your side of the bargain. And it may be costly indeed. And having administered numerous breathalyzers tests, I can tell you that the representative is correct. You do have to blow into that thing for like 30 seconds. So there's a cost to be paid, but remember, we're not making anybody do anything. For the privilege of driving in this state, that they, first of all, violated the first agreement where they said they wouldn't drink and drive, then they did it again, and then they did it again. The state's still willing to let them have an opportunity to drive, but now it's going to be very, very difficult. And if that's a burden on their family, they put that burden on their family, not the state of New Hampshire. So as far as I'm concerned, I think that this is a good bill, and we should pass it and not leave any loopholes.
Representative Muse.
A lot of times in this committee, we're forced to make hard choices between victims and offenders. And to me, this is an easy choice. What we're doing is we're passing a bill that will result in the creation of fewer victims. So I would urge us to pass this bill.
Representative Ray Newman.
I don't want anybody to think that my motivation is to harm victims in any way. I fully agree with removing the stupid ringer on my phone.
I can't say anything because I violated that rule about 20 minutes ago.
Thank you. I appreciate being in the same boat with you. But the thing I am concerned about is I think it's that one sentence is poorly written. I think it could be simply fixed by saying someone who has a requirement to have an interlock device when they drive shall not drive a car without an interlock device. And unless there's some kind of administrative thing that causes them to have something installed, that would solve the problem. Take out the one, take out the loophole, and just say if you are required to have an interlock device, you shall be guilty of X when you drive a car without an interlock device, and that would allow people not have to get caught up in what I think is catch-22, where you have to do a whole bunch of vehicles.
I appreciate that, but my point is, if I put the interlocking device into one vehicle and say, well, it's registered in my name, but I don't drive that one, we'll just leave it in my garage. I don't think it's out of line to have a policy to presume you drive the car registered in your name. So in that case, again, if you get caught violating this law and no one was injured, that's the best case scenario, but the system has already failed because the idea is for you not to be driving without using the interlocking device in the first place. And not only there's literally a tool in their possession on their property that will allow them to get around this rule, and the only way they're going to get caught would be if they were to be pulled over. So my thought is, I appreciate what you're saying, but the idea is we don't want that person driving, period, without exception, without the interlocking device being administered. So that's the concern I have. But I think we can move the question. You may ask a question to Representative Wallace, and you may answer the question.
I had every intention of answering them anyway.
So, the breathalyzer, is the mouthpiece have to be calibrated to the person?
No, it's actually calibrated to a laboratory standard on a monthly basis. We use it looks like something in a physics lab.
All right.
It's
That
calibrated.
was the question.
And because
may I point out one more thing?
Yes, you're so recognized.
Thank you. Is there who is going to enforce this law? Because if it requires interlock devices in all vehicles, are we going to have an enforcement agencies
yes,
doing this?
The service providers, we do that. Okay.
You're going to go to the household and inspect all vehicles?
No, they have to bring their vehicles in on a monthly basis and we look to make sure that the connection points to the vehicle's wiring harness are not tampered with.
Right,
we calibrate the machines because the evidence, the breath samples that device takes are prima facie evidence can be used in a court, and they can convict you of an OUI from the data dump from that device. That's why we calibrate it monthly. to a laboratory standard, not to the individual.
Right, at this time, we'll now move the question. If you in support of the motion of ought to pass, please say yay. If you are opposed, please say nay. The clerk will now call the roll.
Vice Chairman Roy.
Yes.
Representative Welch.
Absolutely.
Representative Burt.
No.
Representative Rhodes.
Yes.
Representative Green. Go on. Clerk votes yes. Representative Testament.
Yes.
Representative True.
Nay.
Representative Pratt.
Yes.
Representative Marston.
No.
Representative Harriet Gathright.
No.
Representative Sue Newman.
Yes.
Representative Jack.
Yes.
Representative Bourdonnais.
No.
Representative Muse.
Yes.
Representative Ray Newman.
No.
Representative Bolden. Representative Conley. Another one. Representative Bradley. Representative Espitia.
Yes.
Chairman Abbas.
The chair votes yes.
11 yeas, 6 nays, and a handful not voting.
By the motion of ought to pass passes, will there be a minority report? Minority report? Will there be a majority report? And whoever, just to point out, this was HB 1465 last year. I bet there's a very good majority report already written, floating around up there. 1465 was the same bill last term. That's what I have in my notes from the. As soon as possible, but noontime tomorrow.
That was Welch. Seconded by Muse, is that what it was?
Yes. So this time we'll now close the executive session on HB 1085. We will not be executing anything else today. Just one bill that was HB 349 was a bill that we passed in the House last year. It was, I don't know the proper term, but it was their version of retained in the other body. Re-refer, I think what they use. Anyway, there was a Senate, they amended that bill. All they amended was the effective date. And that was the bill that would, if you were driving with a suspended license, it would allow you to take in consideration out-of-state convictions that were of similar in nature. So I was going to make a motion to concur with the Senate amendment. It just simply changed the effective date. Anyone have any questions on that bill?
Thank you for telling us.
Seeing, it's HB 349. We passed it in the House last year. It was, I think the term is re-referred, but it was the Senate version of retaining a bill. It was retained in committee. The amendment, all it does is change the effective date. It doesn't change any of the actual subject matter of the bill. So I was going to recommend a motion to concur with the Senate amendment on HB 349. And does anyone have any questions on that?
That's the only change.
That is the only change. If I recall, I'm going off memory. I think it was 14-7 in this committee. I believe it was a voice vote in the. I don't remember off the top of my. I would have to check. I would have to check, but it. At this time, the committee, the Criminal Justice Committee, will now be adjourned. So just while I have everyone here, the deadline we have for bills is